देखिए लोगे दो bill jump से
Pardon to make a mention, my lord.
bill jump one देखिए bill jump
Pardon to make a mention, my lord. My lord, one CRLMC matter. Earlier it was listed before my lord. My lord, by observing that the matter can be settled between the parties, your lordship has fixed it to today. But unfortunately, it has not been listed. I feel
leave it we'll see
let it come on Monday.
not Monday will not burden next week don't burden next week completely full
It can be settled
space
by
at all
It can be settled between the
maybe but next week is not possible at all talk about next to next week yes.
Criminal appeal, my lord, 4-year conviction, my lord.
Huh?
4-year conviction.
4-year conviction you release it next week huh?
Release of money, my lord. In this case, my lord, honorable.
Yes, give it.
After court order is filed, Supreme Court order, my lord.
Supreme Court order what for
Opposite party preferred SLP, my lord, that has been dismissed and directed the order court below this court to dispose of the same, my lord.
where is the order from
Order I have filed in the court IA. I have filed an IA.
get the order and mention it Monday
I have filed IA, my lord.
get that order and mention it Monday if necessary Tuesday I'll take it up get that order where is the order of Supreme Court get that order
The IA, my lord, I have not.
that's right get that order and mention it Monday yes
4 years conviction.
just see 4 years conviction
Monday.
Pardon, my lord.
not Monday
Pardon, my
let
lord.
us see don't see the boards are getting so exhausted then as a result of which no hearing takes place
Hearing.
let us
Okay.
leave it to
Yes.
this side also to adjust the board
Yes. Not bail, my lord.
we'll see bail are you in custody
Yes. Headmaster.
press appeal huh?
Yes. Yes.
Tuesday Wednesday
Pardon, my lord. CRLMC questioning the affair.
take that
Also, my lord.
let's see give the memos will verify
In this case, the court,
yes sir
in this case, I am the I kidnapped allegation that I kidnapped the guy. Father filed the affair, but I and my wife are residing for 4 years, and the one child has also got.
what do you want now quashing
No. I am a. Oh yes, I want that question, and I give all the basis.
give the memo yes.
Question of the further proceeding, my lord. Husband and wife decided to live separate and they have matter settled, my lord.
498
Yes.
देखिए लोग next week there is no 307
No, 498 was, my lord. Other one is, my lord, recalling rejecting 311 petition.
311 we will see first 498 वाला देखिए लोग दियो
But in this case, due to interim order, the husband is not paying any compensation, not only I am being harassed.
आराम से लोग
I don't to mention, my lord. My lord, order pass 5, my lord. Court name is wrong, my lord. SDGM Jaipur होगा तो SDGM Koraput is certified copy.
already modified
Yesterday order was obtained.
okay yesterday
Yesterday.
have you taken certificate copy
No, my lord.
you not taken
Not.
कल delete कर दियो why to list it huh? I'll do it today जयपुर को नहीं कर दिया again we will upload today itself okay
Yes.
Pardon to mention, my lord. The press criminal miscase, my lord, before this Hon'Ble court. Offense under section 379, 506, 34 IPs.
what do you want
379, 506, and 34 IPs, my lord. For theft of the fees, my lord, and the pawn, my lord.
you first decide what do you want
Passing of the cognizance, my lord.
Yes.
Your lordships have, we see your
Yes,
lordships.
The lordship has filed an IA for early hearing of the matter. Actually, the petitioners have been summoned from the session.
what is the date fixed now
27th of March, and they have been.
now
they have been
now we are giving date in May
But your
you
lordship.
should be happy before that there is no scope at all no scope
But if your lordship kindly considers, because they have.
I consider therefore I am saying if I lease that application the application will go in May then your main matter will also go to May see the problem try to understand the problem this side don't seek adjournment on 27th
On 27th, your lordship.
27th
But they have been summoned on the 13th.
all right let us see you can give it to if possible we will see it can be done now I don't know it can be
My lord, one miscase first day, it was posted to yesterday, but unfortunately, the court is adjourned not reached. So I 110/25. Miscase 110/25. First day.
What do you want?
My lord, sir.
What do you want, sir?
Just stay.
List में.
Memo कैसे?
Sir, memo ji. Already filed the memo.
Give that memo.
Already filed.
My lord, GR case of
Published.
2002, my lord. Till today, the trial has not been completed.
Good trial is not complete. Enjoy.
2002, my lord.
It's all right.
Well, I have given several memos.
Oh, keep it alone. Keep it alone.
Your lordships,
April, first week April or something. Yes.
To apology, my lord. Exam 104, my lord, suggested me to file me the 4 year about me the more.
Let me finish up today. Relatively, I have.
No, please, no, what I am saying, I filed me lord to miscase for interim bail because some instructions.
Yes.
4 years inside the custody. See, I get them again that. Please search.
104. It's there, na?
Yes, yes.
Give the copy to him. I'll consider it today.
your lord,
It is in the weekly list.
Yes, no, I
Oh.
get asking.
Next week,
Oh,
to gather
you
that into-
get the IA on record. It is there in the list. I'll pick up any day. Let it be on Monday. How does it make difference?
your lordships,
Activate.
What do you want? Already disposed of.
your lord.
Okay. It's already disposed of. Released. 37. Disposed of. Huh? 37.
Pardon to mention, your lordships.
Yes.
Your lordships, I'm in BC.
Hmm.
Your lordship, there is a specific direction of this honorable court that the matter should be listed after 24/4/2023. Your lordships, the case is Republic of India versus Ramchandra Hasda. Now, lordships, the trial court had exonerated him under the PC Act, and we had filed a revision application, your lordships. And there is no stay in the trial, your lordships. This revision application for invoking 13(1)(d) is pending here, your lordships, and the trial is continuing.
Against discharge you are coming, huh?
Yes, your lordships, but the trial is continuing. Only one offense he has been discharged, that is 13(1)(d). We have filed an application. There was a specific direction of this court that the matter should be listed on 24/4/2023, your lordships.
Give the memo, we'll see. I'll try to get it listed.
Otherwise, your lordship, the matter will become infructuous because the trial is going on.
We'll see. I'll just check it up. Please give the memo.
Yes, your lordships.
Your junior is there? Huh? Let's
Junior
check
is
it up. Okay, we'll list. Okay. Yes.
I didn't to mention.
Any mentioning online? No. Yes.
Item 28, my lord. Item 28 after launch, my lord.
Wait, sir. We'll see. On the list, we'll see. Yes.
Pardon to mention, my lord, item 11.
Yes, mention.
1 minute. List, we'll see. List. Anybody seeks adjournment and list. Please call the list.
Item 1 to 7. To mention, item number 5. Can we take it next week?
5 adjourn, huh? On request. Not next week. Go to May. Yes.
Item number 6. I'm seeking adjournment.
3.
3 minutes.
Yes.
Next week.
May. ठीक है.
Item number 6, my lord. I'm seeking.
6 years. Adjourn. May.
Item number 9, my lord.
Yes.
Next week, my lord.
May.
8 to 21.
Item 11, my lord. My lord, may permit to withdraw the matter.
Withdraw. Huh? Yes. Yes.
22 to 25. 26 to 34.
Item 30, madam.
Item 28, my lord.
Yes. 28. Yes.
After launch, my lord. I will physically appear, my lord.
We'll see. Pass.
Item 30, board side is there, my lord. This is a compromise matter, my lord. The lordship kindly taken upon.
What was the offense?
Offense 307 and other offenses there. Family members, my lord. Simple in nature. The lordship directed to take the instruction about the status of the report. That has not come.
You want an adjournment?
Both are there, my lord.
Joint request adjourn. Joint request 30.
Would it ask me the other policy must be policy?
Joint request adjourn and put it on 28. And 20? Yes. 28.
Your Lordship, item 27, Your Lordship. I seek an adjournment because I'm not pulling well, Your Lordship.
Okay.
The opposite party was supposed to.
27 also adjourn.
Interim order may be
Interim
continued.
order.
Much obliged, Your Lordship.
You should take rest. Why are you coming?
Your
Not-
Lordship.
Take. Yes.
35 and 36.
Let's start.
Item 1.
May I please, Your Lordship?
Yes.
My matter last occasion, Lordship directed to me to verify the judgment of Dhyan Foundation judgment, Your Lordship, regarding release of cattle, Your Lordship. Here, Your Lordship, my case not release of cattle, my case is release of vehicle, Your Lordship, that has been allowed by the trial court, Your Lordship. And the condition has been imposed to deposit 4 lakh rupees, Your Lordship. Here, what
Where is that
happened?
condition? Show me.
Your Lordship, at a glance, the relevant page 14 of the internal page of my brief, Your Lordship.
20?
14, Your Lordship, internal page 14.
Yes.
Here, Lordship, what happened? I am the owner of the vehicle, not the accused, Your Lordship. And the accused persons, Your Lordship, 2 to 4, they are the opposite but this present case, Your Lordship. The Law and Court will directed to release the vehicle in favor of me, subject to deposit of rupees 4,06,000 by me and the accused persons, Lordship. So thereby, Your Lordship, upon such order, Your Lordship, came to page 18, Your Lordship, internal page 18. I deposited my proposal share of rupees 1,01,500 and requested the court to release the vehicle, Your Lordship. The court said that no, it cannot be possible unless until the entire amount be deposited.
Yes, that's the problem. A notice was issued to the other side. What do they say? What do they say? See the total amount.
Other side state and so far the 2 to 4 they are the accused persons.
All right, but three of you, no? 2 to 4. 2, 3, 4. 4 of you should deposit. 4 of you should deposit 4,06,000.
I am not the accused also. I am the owner of the vehicle also.
That's right. I understand. What is the response to who is appearing for
notice
the
to issue, madam.
Huh?
Notice.
Who is appearing?
Most
Because
probably.
yes, issue notice written.
Yes. Let's say I pray. My only handover the vehicle is now.
Owner is liable, my lord.
Whatever, but I am issuing notice for because the 4,06,000 has to be paid by 5 of you. Yes. Both the matters. Issue notice. Yes.
Item 2.
Item 2, Your Lordship, this is interim release of the vehicle, Your Lordship. In the case of NDPS.
Yes, you file the requisite within 2 days. Yes. Yes.
My lord, my application for interim release of the vehicle has been rejected against the said order. This related to application, Your Lordship. Last week, Your Lordship directed whether trial has been concluded or not. Trial is going on, Your Lordship. There is no question.
Huh?
Vehicle, madam.
Vehicle.
Yes.
What is the confiscation proceeding you have initiated?
Let this is NDPS, Your Lordship. After conclusion of the trial, there is question of confiscation, Your Lordship.
I have a judgment on that. You do have that judgment with you.
Sorry, Your Lordship. I have the division major rules of our High Court. That judgment, there is no bar in NDPS too.
Oh, I myself have passed
Yes.
many judgments.
Trial is going on, Your Lordship. There is no question of confiscation.
Trial is going on. You are the owner.
Owner, Your Lordship.
What is the reasoning of the trial court? Let us see why it is rejected. Why it is rejected? So
Relying on the Jitendra Diggal case, the trial court.
Sue me.
My last portion of
page.
My lord, I am coming, Your Lordship. Page 32. Relying on the judgment of single match of Honorable High Court, Your Lordship, Jitendra Kumar Dingal versus State of Orissa, owner accused. On that score, my application has been rejected, Your Lordship.
What is this vehicle?
Swift Desire vehicle. Maruti Swift Desire vehicle. 4-wheeler, Your Lordship. 3 persons were transporting 10 kg of ganja. Ganja was seized from dicky of the vehicle, Your Lordship.
You are one of the accused.
One of the accused.
What do you say? I'll rely upon this.
Yes.
Interim release with let him move application
Yes.
with whatever conditions to be imposed. Will
Yes.
Right on. petitioner is agreed by the order dated 12/11/2021, moved by him under section 457 CRPC, seeking release of the desired VXY vehicle bearing registration number OD dash 15R dash 0821 21, which has been rejected. Okay. The trial court has rejected the application of the petitioner, relying upon the judgment of the which judgment relied upon?
My lord, line and trial court.
Trial court relied upon.
Trial court relying on the judgment of single bench of our High Court, Jitendra Kumar Digal.
Rejected the application of
Jitendra Kumar Digal versus State.
Inter observing agent. Page 28. There is no provision under NDPS. There is no provision under NDPS Act and C paragraph, the second paragraph. The learned counsel for the petitioner, relying upon relying upon the judgment judgment of division bench of this court in criminal division number 503 of 2020-22 and batch submits that the law in this regard is now well settled, and this division bench of this court has already settled the law for that and during the pendency of the trial, the vehicle involved in an NDPS case can be released intermittently. There is no legal bar. There is no legal bar. He has relied upon para 33 and 33 to 36 of the judgment which reads agenda, which reads the counsel for the state submits that the vehicle has been used for commission of the offense, alleged offense punishable under section 20B2 capital B oblique 25 and 27 of NDPS Act. The petitioner is one of the accused therein. The trial in the present case is going on. Yeah, however, insofar as the judgment of the division bench cited by division bench of this court cited by the petitioner is concerned, the counsel for the state has no serious objection to the same. Regarding that to the government, I am of the considered view that the petitioner shall move to his application for the trial court express, and the same shall be considered in the light of the building that the division bench will part in certain and so on. So, accordingly, the impugn order is set aside. The petitioner will be granted liberty to move to the application of the trial court for reconsideration for the press for release of the vehicle subject. In this observation, this program. Yes, next.
Item 4.
Yes, sir. Non-APS for the petitioner. In the last occasion, on request of the counsel for the petitioner, matter was judged in the interest of justice. Adjourn the matter to May, June, whatever. Yes.
Item 7.
Petitioner files an application on 457 for release of the vehicle, my lord, before the London JMFC Ranpur. That is lingering, my lord, till 9 months, my lord.
Sorry?
That is lingering, my lord. I am filed for early disposal of the said petition, my lord. The offences involve only 341.
Your application is pending,
my lord.
You want direction. Where is that application?
Annexure 4, page 16.
Annexure 4?
Page 16.
This is the application pending.
Application is page, my lord, annexure 2. Page 12, my lord.
Where is the order?
Order is annexure 4, my lord.
Which order? Dated?
Orders, entire order sheet I have given, my lord.
Which?
What is your grievance? Your application is not decided.
Early disposal of the.
That's what I'm asking. You say that your application under 457 is not decided,
My lord.
which was filed on. When have you filed this application? There is no date.
No date.
Date.
When have you filed? Is it filed yesterday?
Not, my lord.
Then-
In the month of June, my lord. The order
Tell me
sheet,
the date. I'll have to write it.
The order sheet.
order sheet is reflecting 28 June, my lord.
28 June, yes.
The application, at least you should write the date. Where is that?
16. Page 16.
Page 16.
The order dated 28/6/24. First date, first order.
Hmm.
A petition under section 457 CRPC is filed by the petitioner.
No, the petition and so.
No, it is not
Filed
date.
by.
Yes, yes.
Where is the date?
No, no date.
Where is the date? You filed on 26th. He is only recording that it is filed. But when it is filed?
The 23 of June, my lord.
You are seeking for early disposal. Your application. You should know when you have filed.
Date is not there.
If you don't say that, then I will not pass the order. You must know when you have filed the application, which is pending.
My lord.
From which day it is pending.
23 June, the offense occurred, my lord. Incident occurred. After that.
Normally,
filed.
when the case is posted, particular date, the petition is filed. So on.
I am not on normal. He is asking an unusual order.
He is not able to satisfy.
Unusual order. So therefore, I should write this application is filed on such and such day, which is pending.
Well, next week I will obtain instruction, my lord.
No, you pray there at unnecessary application. Right now. Petitioner
Next week.
is agreed by. The petitioner is agreed by the fact that his application under section 457 CRPC appears to have been filed in the month of June 2024 has not yet been decided by the court below. Therefore, he seeks indulgence of the court. Although there is no date coming forth as to when the application has been filed by the petitioner. However, from the proceedings dated 28/6/2024, it appears that on that day the application was before the court for determination. Be that as it may, since the prayer of the petitioner is innocent, it deserves merit. Therefore, the petitioner is given liberty to request the court below to expeditiously dispose of the application. If such request is made, it is expected that the trial court shall consider it positively. Yes. These are the results in this order. Yes, next.
Item 8, my lord, not press. Not press.
Not pressed. If not pressed, please.
10.
My lord, may I plead the words?
Yes.
Your Lord, what happened in this case? FIR registered under section 493, 417, 506. And allegation is that, my lord, the informant, being the husband, found his wife in a compromised state with the petitioner. Hence, he lost the affair. And
Husband lost the affair.
Husband lost the affair against the wife and
the
present
other man.
petitioner who was there with his wife. Charge sheet submitted on 10/8/2023.
Yes. Who are you? You are the husband.
I am not the husband.
You are the third person.
Yeah, I am third person.
Yes.
Charge sheet submitted on 10/8/2023. Prior to 10 months before, Lordship kindly see that page number 23, page number 23. Order sheet. How it was turned to 376? That's it. How, my lord, your lordship, there are a village meeting was there. Meeting was
Who is
convened.
the informant?
My lord.
Who is the informant?
Informant is the husband of husband.
The statement of the so-called victim
Victim
is recorded under 164.
Victim statement is that is separate, is my lord. How it were turned to 376? The entire
I understand it. I understand it.
Order sheet shows, my lord. ताकू डाकिले village meeting की से गलानी threaten गला. Hence 37 turned to 376. Yeah, order sheet shows. Magistrate order. Yes.
Where is that order?
Page number 23. Order dated 26/10/22. The case record is put up today on strength of an intimation received from the IO.
Where are you reading, sir?
Page number 23.
26/10/2022. Order?
Dated 26/10/22.
Yes. This case record is put up today.
Put up today on strength of an intimation received from the IO S. Khalo, SI of Contamanji PS through Learned APP for turning of section 419, 417, 506 IP to 376. The IO has stated that informant lodged an FR stating therein that on so and so at about 4 p.m. accused Husi Grevela developed sexual relation with his wife. Thereafter, a meeting was called at village, but the accused did not turn up. Rather, threatened to kill the informant in life. During course of investigation, it is ascertained that the accused forcibly made naked, so and so and so. After the incident, the accused fled away from the home.
But it all depends upon the statement of the prosecutrix. Where is the statement of the prosecutrix?
That is not with me.
That is the whole 493. The
Yes.
husband.
493.
No, the husband thought that they were in relationship.
Yes.
And
that
if
is
the wife,
that is reflected in the affair.
But in the wife, if wife in 164 or 161 says no, forcibly he has done. Having a relationship, having sexual intercourse is two different things.
Yes.
What is he saying? That is very important. Where is 161 statement?
Presently not with me.
Then.
And I have.
And you implead at least the informant. I'll
Yes.
issue notice. Informant and victim. I'll issue notice. Implead. Let counsel for the petitioners seek leave of this court to implead the victim and the informant in the present case is opposite party number 2 and 3. Issue notice to the opposite party number 2 and newly impleaded opposite party 2 and 3. 2 and 3. So accept notice for the state. And the service of the notice on opposite party number 2 and 3 be served through the IAC, IO of the case. Let us see, let them come.
Yes, my lord. Here, my lord, he was on anticipatory well.
That's all right, let them come. We'll see. Yes.
Then I will file and consolidated.
Yes, give an extra copy so that we will send
It will serve through IO.
and file a memo.
Consolidated cost title.
Yes.
My lord.
M12.
My lord. My lord, this quashing application filed victim and accused. Also, in meantime, both are legally married. In meantime, both are legally married. Marriage certificate annexure 4.
Annexure 5, na, page 25.
Oh, both of them have filed together.
But at the time of incident, the victim was 17 years, 5 months, 28 days, your lord. So
What is the age now?
But now she became major.
What is it?
But marriage certificate, your lordship, page 25.
Where is that?
Page 25.
Yes.
Lordship, kindly see annexure 3. Annexure 3.
Birth certificate.
Birth certificate.
Yes.
Date of occurrence, victim lady is major.
2005, 9/9/2005.
5. Date of occurrence 1st March 2024. In meantime, victim lady major.
No, that's right. When the date of incident?
Date of incident 1st March 2024.
By that time, what was this?
Age 18 plus. 18 वर्ष 6 months.
But charge sheet has been filed. Police has clearly stated on verification of the school register, it was came to light
What
that.
is he filing birth certificate?
Verification, Xerox copy of the high school.
But the charge sheet has police has clearly
See,
stated.
two things are clear. One is birth certificate, she was major.
Yes.
Second is both of them are married. The marriage certificate is produced and valid marriage. This is the marriage
Yes, sir,
registration certificate.
Section 5 the marriage age.
Both of them are married. What is the age written there?
January 2025 रे विवाह रही से तो बस रही।
Bring them.
Yes.
Bring them.
Yes.
Huh?
Yes.
Bring them next week. Bring them.
Yes, Your Lordship.
Covered by that, my judgment. Recent judgment. You just.
Recent judgment, sir. Odisha High Court judgment.
Which one?
Justice Savitri Rathore related to the.
Huh? My judgment. My judgment. Let it be. Keep it on 13. 1-3. Bring them. Just I want to see that whether the girl is happy or not.
Yes.
The parents have accepted.
No.
Both the parents.
No. Meeting parents not accepted.
Who is the informant here?
Father.
Then that's another problem.
Sir,
I'm issuing notice to the father.
date of occurrence is major.
All right, let us issue notice to the informant. Otherwise, he will create problem further. Serve the notice through IH. Yeah.
Yes, Your Lordship.
Save the notice.
Yes.
And let it be on 17. 17. Okay. Bring the girl. Let the father come. He may change his mind. Seeing the daughter. Yes.
Obliges.
30.
That is related to the.
What is the stage? 1 minute.
But
What is the stage?
FIR March 2024 I have no instruction.
Investigation is going on. Charge
sheet filed.
Cognizance.
That part I have not filed. My lawyer friend has not filed any documents regarding other.
What is the stage?
Cognizance has been taken.
Charge from
Cognizance.
There is no stay then. Stay is not required.
Not to start.
Yes.
Yes. Issue notice. Service on informant through IH. 70. Yes.
14.
13, no?
Sorry, no.
Huh?
What?
13, what happened? 12th? You are appearing in that matter? Which one? Court title just see. What is the court title? What is the name of the petitioner?
Ramakrishna Das.
It is something different. Gautam Malik. 12. That was 12. Yes, 13. Why are you confused? I don't understand. 12 is over now. 13. Yes.
Matter relating to passing of criminal proceeding and fitting cognizance. Case is arising out of complaint case. The message that the complaint is a process of her. So say someone the page so petitioner notice receive not working. So it some obstructing some discharging his duty and some filthy language. So the petitioner is a government teacher, my lord, and section number 2 is wife.
I'll issue notice. Let us see. Okay.
The chances of settlement compromise.
Therefore, I am issuing notice. What is the stage? Appearance stage. So appearance is that nothing great is going to happen. Just file the process, we'll see.
Pardon, my lord.
My lordship.
Pardon, my lord. My lord, see, to item note 12, I no question.
That's what I asked you. You were going and I asked you. Stay kar diya. 12. 12 I stay of the further proceeding. That's what I asked you. What did you say?
Sorry.
Both of them are married. Unnecessarily, the married couple will be created trouble.
Yeah.
Yes.
Please, my lordship.
Yes, sir.
My lordship would say due to non-registration of flats, the OPID have all the 512 flats have been registered. Due to non-registration of the flats in 2016, they initiated a proceeding against me under Section 6 of the OPID Act. Now, ultimately, the High Court held in its judgment, relying upon the Bombay High Court judgment, that it is incongruous that under the OPID Act, there are two procedures contemplated. One is the civil procedure, one is the criminal procedure. Here the cognizance is taken by this criminal procedure.
Six OPID.
6. And then 9 talks of a procedure contemplated under the civil procedure code. My lordship would just have one paragraph.
Now, what is this, by the way? You have given how many people are involved?
No one.
500.
No, I'm challenging the quashing of the cognizance.
Cognizance insofar as section 6 is concerned.
6 is concerned. Why? Because of the simple fact that the court has already held it is a civil proceeding, and the Supreme Court has also held that for non-registration of flats.
Let me first understand why have you given this?
Why? Because the initiation was for non-registration of the flats.
Flats, 512 flats.
But it has been registered now.
Now registered.
Now registered. Now the Supreme Court stated, my lords, one second. The Supreme Court stated that non-registration of flats does not constitute a criminal offence. That is last page. My lordship sees.
Yes.
Last page.
Yes.
Paragraph 12.
Yes. In the instant case, the parties were not interested with you.
In the present case, the appellant are not entrusted with the property by the respondent number 2. The only delivery was made as part of the payment towards the agreement and sell. The amount paid to so and so have left been untrusted. Additionally, merely because the appellant was refusing to register the sale, it does not amount to misappropriation of the advance paid. Since there is no entrustment of the property, the offence of misappropriation of such amount, thereby criminal breach of trust, cannot be said to be made out. Then, the act of the appellant at best constitutes a civil wrong.
You had given possession to all of them?
All possession. It is there. Possession date is also there. So now, this judgment of the High Court, which I have given my lordship would say why they say it is incongruous. Because they say in one OPID Act, one there is a civil proceeding, there is also a criminal proceeding. They said in one act, there cannot be two proceedings under
Let us see the allegation first of all. Where is the charge sheet? Show me the allegation.
Charge sheet I have given, my lord. The charge sheet is
Where
there.
is that?
No, but my lordship would only see 19 and then I'll come.
I understood, but let us see the allegation again.
Allegation. Allegation is non-registration. Allegation, my lordship sees, is non-registration.
Where is that?
One is a preliminary and one is a final. It's only the statements. The court. One sec, my lord. Here, my lord. Again. This is the final charge sheet my lordship sees at the top. For non-registration of the flats. And there's a coordinate bench which has already passed an order of stay of the proceedings. Again. My Lord Justice Panigrahi.
Yes.
My lordship sees. Proceedings have been stayed, but here because it is a civil proceeding, criminal cannot be initiated.
What do you say?
My submission, my lord. Can I blame the FR?
See, your allegation are twofold, what I understood. First thing is, he has promised to do some fixtures, this, that he was supposed to give. This is one thing. Second is which he has not given. This is one allegation. Second allegation is, he has not registered the flat. Fact remains that the flats are, possession is given.
No, he's saying I have no exception.
1 minute.
No.
That's what his case is.
No.
The possession is given. Whether as per
Registration is done.
1 minute, as per the condition, as per the promises which he made, that fixtures will be given, this will be given, that will be given. If it's not given, there is no criminal liability. You have to go to a consumer court for enforcing the deficiency in his service. No criminality comes in. Insofar non-registration is concerned, now he says it is registered, and entrustment part is also doesn't come because the flats are given to you. It's not a case where the money is taken and the flat is not given to you at all. Here is a case, money was taken, flat is given. However, the flat is not given as per the promises made by them without fixtures and all. And second is, the registration is not made. There was a problem in the registration in Orissa, as you know, the Apartment Act. Not now that is solved, and now registration has started. Moreover, registration has been done according to him. So, where is the criminality?
Here, my lord, my submission, my lord, that instance I will take, my lord, whether all the flat are registered or not, my lord. Whether he, then, my lord, here, if you kindly have a glance to the prayer, my lord. He has challenged the cognizance, my lord, dated 2018, my lord. He has specifically stated, my lord, in para 3, my lord, when the discharge petition has been rejected, my lord, how, my lord, now he has challenged the cognizance, my lord. In 2020, discharge petition has been rejected. Para 3, my lord, can you have a glance, my lord?
So that my answer is very simple. They gave me the final charge sheet in 24, December 24. They have given me.
Then you challenge that charge sheet.
My lords,
Challenge that charge sheet.
that is what I have challenged. I have put that charge sheet there. And what they have done, my lordship sees the first page. What they have done under section 20. Article 20, subclause 2, they filed 2 cases. My lordship sees at the first page. In the matter of an application of quashing of the criminal proceeding, 16 of 20, which has been
you just tell me whether you moved an application for discharge which has been turned down.
It has been turned down.
Then how can I now?
No, because now this judgment has come. It is a civil proceeding. There cannot be a criminal proceeding.
You challenge that order, discharge order.
That is what I have challenged. I have already obtained a stay.
Where is that?
That I gave my lordship.
That was challenged.
Maybe another case, not this case.
No, this case. That is what I have challenged.
Oh, then please challenge. I'll issue notice. Issue notice. Stay is already operating. In that matter.
No further proceeding.
Already
there is stay.
But my lordship would write here because they are planning to issue me charges against me. That has to be stayed.
But the discharge application which was turned down, you challenge that order before the coordinate bench.
Yes.
You got a stay. What stay is required now?
My lordship would say this. Otherwise it will.
I'll record it. No stay is required now. Show me that order.
That is a different case, my lords. This is 16 and this is 18. Identical.
Separate.
That is why I said that is why I said.
When the matter is fixed now? Before trial court?
Today. They have called me to submit the charge today.
A charge sheet. Copy of charge sheet. Copy of charge sheet they are giving today. Then
not charge sheet. The charge.
Charge.
Frame kari bhai. If my lordship would not stay, then I will be affected. Because my lordship sees I am being very fair.
There are 2 cases registered by 2 different investors. In one case, he moved an application for discharge, which was turned down, and he comes to this court, and the court stays that proceeding. In other case, he is challenging cognizance order, and stay has to be granted. It can't be in 2.
No. Let me verify that order, my lord. This case already challenged or not?
Certificate copy, just check it out. Certificate copy.
If you see the judgment.
Certificate copy, just check it out.
I'm deeply obliged, my lordship, because under 20, my lords, Article 20, subclause 2, I cannot be prosecuted for the same offence twice. One is 16, the second one is 18.
Who is the complainant there?
One of the flat owners.
In the same project. Same project.
Same project.
Then.
My lordship says that. And
Oh,
Here, my lord, impute order dated 31/7/24, my lord. That was challenged, my lord.
all right.
That is the.
What is the impute order? It is 31/7/24.
See what has happened in the same project.
Same project.
Two investors have filed two FIRs.
You have filed two FIRs.
In one FIR, this is the result. In the other FIR, why should he suffer? Right down. Petitioner, Mr. Rai and counsel for the petitioner submits that the petitioner two FIR, namely FIR number?
FIR number 18 of 2016.
18 of 2016 and
16 of 2016.
16 of 2016 has been registered against the petitioners by two investors. In which project? Which project? Project name is?
Seven Hills Estate Limited.
No, project. Which
That
project?
is Seven Hills, the matter of Seven Hills Estate Limited.
I'm talking about the project.
The project is Seven Hills Estate Limited.
In the same project, in the same project. In the same project. He further submits that the allegation imprecise is that the investors in both the FIRs have agreed by the fact that the flats, though handed over to them, has not yet been registered, and as per the promise made by the developer, the fixtures and all other facilities are not given to them. Insofar as the FIR number 16 of 2018, 16 of 2016 is concerned, the charge sheet was filed. The petitioner moved an application for discharge, which was turned down by the impugn order dated. Then certificate copy. Impugn order dated. Where is the impugn order? Impugn order dated 31/7/2024. The petitioner 2024. The petitioner assailed the said order passed by the designated court, presiding officer designated court, Cuttack, by filing FAO number 472 of 2024. The coordinate bench of this court, while issuing notice to the opposite party, has passed an interim order, inter alia, observing agenda. As an interim measure, it is directed that the operation of the impugn order / judgment dated 31/7/2024, passed by the lieutenant presiding officer, designated court under OPID Act Cuttack, IA number 3 of 2018, shall remain stayed till the next date of listing of the matter. Mr. Ray, Lieutenant Counsel for the petitioner, submits that the present case is emanating from the other connected FIR. In the present case, the petitioner has assailing the order of cognizance dated 21/11/2018, passed by the Lieutenant OPID designated court, OPID Act Cuttack. Mr. Mishra, and counsel for the OPID, accept notice. He opposes the interim prayer. He submits that in the present case is also discharge application.
Yes, para 3 they have mentioned.
He submits that in the present case as well, the application moved by the present petitioners for discharge has been rejected.
Under section 239 CRPC has been rejected.
Discharge under section 239 CRPC has been rejected. Therefore, after having obtained a rejection order from the trial court on their application for discharge, it is not open for the petitioners to assail the order of cognizance dated 21/11/2018. To confront with the said position, Mr. Rai submits that the petitioner is not only challenging the cognizance order, but also challenging the entire criminal prosecution initiated against them by the informant, Be that as it may, the scope of the petition shall be considered on the next date of hearing. In the meantime, the proceeding before the court below emanating from the FIR number 18 of 2016 pending before the designated court is stayed, and tag this matter along with the FAO number shown.
It shall be called. It look like.
One extra copy be submitted.
And the extra copy you said.
Yes. And issue notice to the opposite party. Deeply obliged, my lord.
Yes.
May I have pardon my
Yes, sir.
Item 13, my lord. The case is pending in the Gramanala, Raghunathpur under section 205 TRC. But stay maybe
I just forget what you argued in the main matter. What was the matter, by the way?
Case is arising out of complaint case. Process about
They are settling. Shall I send it to mediation? He is a process server. Why that? A process server had gone.
Kindly issue notice to the complaint.
I have already issued notice. I'll send it to mediation and stay the proceeding. He is a process server. He went to serve the process. Something happened.
Yes, sir.
Right on. The petitioner is challenging the entire, challenging the order dated 5/1/2022 passed by the which court? Passed by JMFC Gamnale, whereby cognizance of offence punishable under offences punishable under section 294, 353, 186, 506, 34 IPC has been registered, has been taken. The allegation against the petitioner is so and so. Learned counsel for the petitioner submits that the parties are likely to settle the dispute, Mr. Mahanti accept notice, and he submits that there is no harm in exploring a possibility of settlement in view of the minor nature of the allegation made against the petitioner. In view of where will you go? Gramanala? That is in Puri district.
Jagatsinghpur district.
The mediation center. Why?
Yes, sir.
Local people they will go. In view of the aforementioned matter is referred to district mediation center, Jagatsinghpur. Jagatsinghpur. Order kar do. In the meantime, proceeding before the court. Which court? Gramanale. Gramanale, Raghunathpur. In ICC case number 23 of 2021 is state. Yes. Awaiting mediation report list. Yes.
Item 15. Nay, please, Lordship. And in receipt.
Yes.
NBW was issued on dated 8/2/2024, Lordship. This is a CBI matter, and the petitioner was never arrested. He was only sent notice, and thereafter he has appeared in the court.
Yes.
Lordships, the similar kind of matter. Day before yesterday, your lordships had passed an order, your lordships in
he'll surrender resort to the remedy. Honor before 31st surrender. He was never in. The petitioner was not on bail. On the request of IO.
No, Lordship, he was on bail, your lordships.
He was on bail. He says
that's a wrong statement, your lordships. He was on bail, your lordships. He was on bail. Your lordships have noted down the date. The accused, your lordships, on 4/1/2011, summons were issued to him. Then after that, your lordships, he took bail. After taking bail, your lordships, he did not appear for 10-12 years, your lordships. After 14 years, NPW has been issued because he never joined.
Okay. The petitioner was on bail. However, subsequently, he did not appear before the court as a result of which NBW was issued on 8/2/2024. 30th March to register to the remedy. Till then, the execution of NBW shall remain stay.
But so it is not necessary, Your Lordships. He may surrender and seek the remedy. Anyways, is not available, Your Lordships.
I am saying he has to appear before the 30th appear, resort to the remedy. Otherwise, this concession goes. It is good for you only. Otherwise, your officer will be unnecessarily engaged.
Your Lordships, if he'll get protection till that date, he'll go and surrender and.
I only say that execution will be stayed and he'll appear on that such and such. That's all. Yes.
Right. 16.
My lord,
25
prayer for quashing of
2524 is the date of NBW, Lordship. Date of release and bail on 16/10/2023 by this honorable court, Lordship.
Okay, 500, yes.
17.
My lord, who was issued.
I have allowed, sir. I have allowed.
10/11/23, my lord. Annexed.
Huh?
Date of NBW is 10/11/2023, date of release and bail 27/1/2023, Lordship, by this honorable.
By this honorable.
Okay, 500.
18.
1000.
My lord, NBW was issued on 27/2/2024 and earlier 41 has already been complied. He was not arrested.
You were on police bail and NBW issued on
27/2/2024.
24. Okay.
Page 8.
500, yes.
19.
Petitioner was released on bail 5/4/2017 and the NVW issued dated 21/11/2019.
19. Yes. 1000. Yes.
20.
This one was released on bail 4/1/2018 and on 23/3/2023, my lord, NBW was issued, my lord.
Okay, 1000. Yes.
At page 15.
21.
My lord, may kindly see the order dated 14/2/25 and 3/3/25.
Yes. 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 Who is it?
No, sir, it's calling. Sir, upon petitioner, ମୁଁ କଣ କହିଲି?
Yes, sir.
8/21. ମୁଁ ଦିଟା order ପଠେଇଦେଲି।
Oh, sir, actually in this matter.
No, in fact, the first grievance is behind his back, your junior came, you may not be knowing, your junior came and sought for an adjournment without informing him. So therefore, he came and mentioned before court. I said you sort it out. This issue.
The client was sitting here. He is also a lawyer and he is also a.
It's all right. Leave it. Let us come to the point.
Yes.
Let us come to the point.
Yes.
Yeah.
At least they should inform me, nothing else.
That is the understanding in the bar. Yes.
Now,
Here.
this matter, what has happened, one reason for which actually I want that matter to be taken up some other day, that the suit on the basis of which the respondent, here the opposite party's client, claims title of the property was ex parte. So ex parte order was, application was filed to set aside the same, that was rejected.
Sir, please use my.
That was rejected. Now the matter is pending before the Discharge in Civil Division. The matter is pending there. So the delay has been condoned in the meantime. The matter came to the High Court. So now it is fixed to someday. Actually, the petitioner is also a lawyer. In fact, it's between two lawyer families. Actually, the fighting is going on. So if your lordship call this matter 2 weeks after, if necessary, I may not press this application also.
What do you say, Mr. Bo?
My lord, may kindly hear me for a moment. Which my learned senior is saying that is not the real fact which is there. Your lordship may see this now. The first appeal was dismissed 12 years ago. 8 applications for CMA was filed. All the 8 applications were dismissed. Against that, I came up. This court directed, finally it should be decided. He condoned the delay without issuing notice. I came up in civil division. Civil division, this is the judgment wherein it has been held that such condemnation cannot be done. So now the appeal is no more in existence.
No, the revision, civil division.
Civil division. The delay was the 8 applications has been dismissed. One after another applications were filed to restore. Matlab, can it be restored? All these 7 applications having been dismissed. Now what will happen? If the 8th one is restored, the 7th one has to be restored again. 6th, 5th, 4th, 3rd, 2nd, 1st, then the original. Matlab, how many applications will be restored?
No, what is here?
Now in the review, what is the ground your lordship may see? Review, there are the second appellants before this honorable court against a reversing judgment. The documents which they now want to introduce, was it not on their part to introduce at this stage of second appellate by order 41 rule 27? In application, have they whispered a word that when they got the documents, they got the documents during pendency of the second appeal or after the second appeal? Nothing is whispered. Can this document be accepted by this court in a review application? A point which is not urged before the original court, can it be urged in a review? Even if so, then he has to put substantial points before your lordship that these documents were not in my custody. These are public documents.
Yes.
How can that be? How can they review for entertain such an document?
When these documents were discovered, that's an issue.
That they have not whispered. That they have not whispered.
If they've got hold of this document,
yes,
which is substantive document, after the disposal up to the second appeal.
No,
then
after disposal of the
where that mentioned?
After disposal of
second
the
appeal.
second appeal. That's what I'm saying.
Where that mentioned? It's a public document of the year 19.
But we can hear it, but you tell me if he says that
clarify what is happening now with this. Now in the trial court, in execution, they set up another person, file an application under order 21 rule 97. That was also rejected. Against that, they filed a CMP. First of all, it's an appealable order because it's a decree.
Yes.
They have filed a CMP. In CMP, till that I have appeared, no copy has been served. Because
those things are
it's a different thing. 88 document, second appeal was dismissed on.
Now, what is your apprehension? Now, there is no stay. There is no stay.
No stay. They are showing and their execution is not proceeding.
I'll just clarify that.
Yes. Your lordship may clarify the execution will take its own.
Execution because there is no stay.
No stay.
I am not.
That much your lordship may clarify. And this judgment your lordship will see 8 applications dismissed. Now they say it is appeal is pending.
Let us see if he can come out with some solution.
Right.
Is there any chance of settlement?
No.
No chance. Right.
After having fought such a long battle, do your lordship think that there will be a settlement?
The present review petition is pending since 11/9/2020 against the final judgment. Final judgment dated 10/8/2023 passed by this court, the court bench of this court in RSA number 59/2014. The order impugned in the review petition has operation of the order impugned in the review petition has not been stayed. The matter was heard many occasions, and eventually it was heard on 3/3/2025 and 3/3/25, and the following order was passed. 3/3/2025. When the matter is taken up today, SP Mishra, senior counsel, appearing for the appellant, petitioner, submits that let the matter be taken up after 2 weeks, so that there is what should I write? Simply I write 2 weeks, or shall I tell?
2 weeks. Within 2 weeks, any date you are saying.
2 weeks. Why for you are asking that I'll record because he's opposing?
Sir, your lordship will do one thing. Next week, your lordship may call so that I can talk to him.
He is only requesting to release the matter after 2 weeks for addressing the court regarding the merits of the review petition. Release the matter after 2 weeks. I've clarified that. Okay. Release the matter after 2 weeks.
Your Lordship may say that execution should proceed.
No, I will not. I will not direct execution.
No.
But I have said that there is no stay.
Yes.
That I have said.
Yes.
That I have said. Why should I direct the
Yes,
execution
yes,
court?
my lord.
Whether he does it or doesn't.
No, my lord, it is an indication.
It's a fact that there is no stay.
That's what I say. Simply, I have recorded that. Yes.
If you want, the stay will be granted.
The review is not maintainable. What is the question?
What Mr. Mishra is saying is, I'll grant the stay for 2 weeks, thereafter it dismissed. That's what he said.
If that is your Lordship may say 2 weeks stay, thereafter dismissed. I am agree.
No, it will be considered for dismissal after 2 weeks, let the stay be there.
See,
Mr. Mishra fairly submits that it may be dismissed after 2 weeks. That I am ready.
now he says consider.
It's a very problematic man. No, my senior. I cannot fight with him.
You have learned from him then,
Yes,
obviously.
sir. He is my guru.
Yes.
22.
He wants to keep me in the position of Bhishma.
No. Drona.
Drona.
Not Bhishma.
Yes.
I beg to submit my learn. I filed it to amendment petition.
Which?
7879. Formal. That
22. Okay.
that way.
Yes, sir.
Amendment petition I filed my learn. 7879. Two petitions are there.
What is the amendment?
Amendment to two gazettes are there. 90 and 93 gazette. That is as an annexure I filed it.
What in review petition amendment? Anyway,
That is the judgment.
The number.
I'll allow it. I'll decide it on merits.
That is a government. That is the judgment.
For the reasons stated in the application, both the 78, 79. For the reasons stated in the application, the same is allowed. The petitioner is granted 1 week time to file consolidated petition. Release the matter also. How does it make difference? Yes.
Right, copy of the condemnation of delay petition.
Delay ta hojur achu asu.
Apun dein copy de. Copy de.
Next
Yes.
23.
Please, your lordship. 23, I am there virtually.
Yes.
My lords, here the petitioner is a company which is aggrieved by an order dated 18/11/2023, refusing its prayer for being discharged from the offences under sections 120B, read with 420 of the IPC, my lords. Now, my lords, the facts that lead to this application for discharge are that an FIR was lodged by the CBI suo motu, my lords, against 6 persons, my lords.
Yes.
And that was lodged in 2007 under sections 120B, read with 409, 420, 467, 468, and 477A.
You are ready? Mr. Naik, are you ready?
Yes, I'm ready, your lordships.
Now, my lords, in this FIR, my lords, 6 persons were accused, my lords. That is one Surendranath Das, who is said to be the proprietor of Bajrang Agency and managing director of Interlink Private Limited. Then one Ramkrishna Mishra, proprietor of Man Machine Material Paradip. One Ramkumar Sethi, senior manager IOB. One Barnabas Samad, deputy manager IOB. One Rosananda Maji, assistant manager IOB. And Abhay Kumar Rona, deputy manager IOB.
Yes.
Now, this FIR I have annexed to my petition as Annexure 2. Now, if your lordship will see the FIR at Annexure 2.
Annexure 2?
Yes, my lords.
Yes.
My lords may kindly see a running page 26, my lords. That is the FIR begins.
26.
My lords.
Yes.
The chief regional manager IOB is the informant, my lords. He says that I so-and-so, chief regional manager, am competent and duly authorized by bank to lodge a complaint on behalf of the bank in respect of fraud perpetuated by Surendranath Das
Yes.
Proprietor Bajrang Agency and Managing Director Interlink, Sri Ramakrishna Mishra, Proprietor Man Machine Material, in collusion with R.K. Sethi, Senior Manager, B. Samad, Deputy Manager, R.N. Majhi, Assistant Manager, and A.K. Rana, Deputy Manager. It is stated, my lords, that in pursuant of that conspiracy, Sethi, the then Senior Manager IOB, Paradip Branch, allowed opening of following bank accounts by Surendranath Das and Ramakrishna Mishra. Number one is a current account in the name of Bajrang Agency, proprietor Surendra Das. Then a cash credit account in the name of Bajrang Agency, proprietor Surendra Das. Then current account in the name of Interlink to be operated by its MD, Surendranath Das. Then another current account in the name of Man Machine Material, proprietor was Ramakrishna Mishra. Then he says, Konark Suppliers is a proprietary concern of which Basanta Kumar Parida is the proprietor of the firm. It is reported that the bank officers have not seen Basanta Parida, who never visited the bank also. And it is suspected that Surendranath Das and Ramakrishna Mishra have carried out transactions in the current account in the name of Konark Suppliers. And it is reported that Surendra Das and Ramakrishna Mishra have started transactions in the account of Konark Suppliers from October 2002. And it is suspected that the signature of Basanta Parida is forced and all transactions in the account of Konark Suppliers were undertaken by Surendra Das and Ramakrishna Mishra. Transactions gradually increased and huge turnover was reflected in the account. The accounts opened with the bank under the names of Bajrang Agency.
I read that you come to page para 4.
My lords. Says the aforesaid Surendra Das and Ramakrishna Mishra deposited checks drawn on other banks issued by their own group members and indulged in kite flying operations. In the process, aforesaid Sethi allowed overdrafts beyond his discretionary powers continuously and not reported the same to the higher authorities, thereby fraudulently suppressed the facts. Extent of loss now reported is the culmination of transactions, other activities going on over a period of 1.5 years in the above accounts, and the bank is now exposed to a loss of rupees so and so without any security in the account of Interlink Private Limited.
Yes.
Then what he says is,
yes, then what do you say?
My lords, my submission is this. This investigation on the allegations against 6 persons, my lords, culminated into a charge sheet against 7 persons. Now the 7th person who was added in the charge sheet was Interlink Private Limited, my lords. That is the corporation.
Not the Interlink was earlier there in the FIR
No,
itself.
Interlink was not there. The managing director of Interlink was there.
No, come, then go to para 6. Para 6, page 28, 29. Yes. Come to para 6.
The current account of Interlink was opened on 1/8/2005.
Yes.
The first debit balance in the account was such and such on 12/8/2005 due to debit of account for return of check number such and such.
So the Interlink was there.
Interlink's current account is referred to, but Interlink is not an accused. That's why I said that your lordship may kindly see at page 25 who are the accused persons.
I know that I have seen. That I have seen.
The accused persons are 6 in the FIR, my lords.
Okay, you have been added according to you. Yes.
In the charge sheet, my lords, Interlink was added as an accused.
Yes.
My lords may kindly see the charge sheet, which I have also annexed, my lords, as annexure 3, my lords.
Yes, we part.
In the charge sheet, your lordship may kindly see
Yes.
paragraph, page 40, my lords may see.
Yes.
Page 40, he writes, investigation has revealed that Sri S.N. Das had made payment to parties who were either suppliers of iron ore fines or transport or stevedorizing contractors as mentioned in Annexure F of the charge sheet. Investigation has revealed that S.N. Das was the main conspirator and beneficiary of the aforesaid fraud. He also controlled the operation of various firms, bank accounts, names of sister concerns shown to be opened by his associates. And he was mainly instrumental in dishonestly availing overdraft facilities and transferring the proceeds in an illegal manner. He was also responsible for submitting various demand bills, local checks for purchase, even though he was aware that the aforesaid bank accounts did not have sufficient balance to meet the account.
The complexity of S.N. Das is there.
Yes.
And he is the managing director of Interlink.
Yes, my lords, he is also the proprietor of
the current account transaction has taken place.
My submission is this. He is also the proprietor of certain accounts.
Yes.
As proprietor also he is named as an accused. Now, my lords may see what the CBI themselves say in their affidavit which they have filed. In
Yes.
their own counter affidavit.
Yes.
What do they say? Now, they have filed an affidavit stated to be a counter affidavit.
Yes.
Wherein that is sworn by one Vikas Kumar, my lords, Inspector of Police.
Which paragraph?
Yes, I am coming. Paragraph 4, my lords, miss. Paragraph 3, your lordship may see. Para 2, page 2. That CBI Bank Security and Fraud Cell, Calcutta, registered BAM fraud case number such and such under section so and so against accused persons, namely, one is Surendra Das, proprietor Bajrang Agency, managing director of Interlink. Then Ramkrishna Mishra, proprietor Man Machine Materials. Ramkumar Sethi, senior manager IOB. Then Barnabas Samad, deputy manager IOB.
All the names are there.
Yes, 6 persons are there. Then what he says, after investigation of the case, CBI filed charge sheet in the Court of Special Judge under section 120B read with 420 and 477A IPC and 13.2 read with 13.1 C and D PC Act against 7 accused persons. And the 7th entity, my lords, is Interlink Private Limited.
Yes.
Now, my lords, then what he says is this. Paragraph 6, my lords may see at page 7. He says that the accused petitioner, the managing director of Interlink, Sri Surendra Das, filed CRLMC number such and such in the Honorable High Court, rejected by the Honorable Court. Accused again filed CRLMC 1763 of 2011 in the Honorable High Court, dismissed by the Honorable High Court. Accused petitioner also filed CRLMC.
What do you want to say out of it?
Yes. What I want to say is, now my lords may come to the point-wise reply, which he has made.
Yes.
He says, at paragraph H at page 10.
Yes, I'm there.
That the averments made under para 8 of the petition is denied. It is submitted that the directors of a company are the actual working brain behind the company as to acts or omissions or commissions done on their part in the capacity of director. A company is merely a legal entity without presence of conscious mind of human being. And
What is wrong in it?
Well, I am coming to that. And a company cannot run under the umbrella of company as a legal entity. applicants for business purpose were the concerned directors of the company. All terms and conditions are accepted by them in the capacity of directors before getting dispersal. Or the entire thing is, he says that it was the act of the applicants, of the directors, my lords. So how is the company concerned? How can the company become a co-conspirator, my lords?
Yes.
The company is liable for having committed offenses as a company, but it doesn't have a mind of its own. That's what they themselves say.
And what else? Any other point?
This is the sole point, my lords. How can the company be a conspirator, not
Yes.
having a mind of its own?
Naik, what do you say?
May I please, Your Lordships? Your Lordships, if Your Lordships will read the last orders, Lordships, I've given a small compilation of orders of the last orders passed.
Meet the argument.
I'm
That's
meeting that. No, Your Lordships.
Hmm.
I'll meet the arguments, Your Lordships, because Your Lordships, I need to argue my case on its merits and then meet his arguments. On merits, Your Lordships.
Understood.
No, Your Lordships. Your Lordships, this discharge application was once rejected by this Honorable Court. Your Lordship,
that you have written in the.
No, Your Lordships, I'll also talk. I need to demonstrate it, Your Lordships. Your Lordship, may kindly come to your order dated, which was passed by Your Lordships. Order dated. Your Lordships, order dated 21/3/2024.
21/3, okay. Yes.
Mr. Panda, learned counsel for the petitioner seeks time to file an illustrative chart of the case and would make endeavor to place on record order dated 29/4/2011 by the next date. Now, Lordships, I'm filing this order dated 29/4/2011, Your Lordships.
Yes.
That was not placed.
Yes.
If Your Lordships, I have given a compilation, Lordships may kindly come straight to the first page.
Okay.
The first page, Your Lordships will see Interlink Private Limited through its managing director.
Yes.
This application CRLMC 1763 of 2011, Your Lordships, was passed against the rejection of a discharge order, which is in page 14, Your Lordships. That page 14 is order dated 29/4/2011, which Your Lordships wanted to peruse. Now, Lordship may kindly come to page 14.
14
Page 14 is order dated 29/4/2011, in which the discharge application pertaining to the same facts, same cause of action, same accused, the company has been discarded and rejected by the lower court, Your Lordships.
Okay.
Your Lordships, is page 14, Your Lordships?
Page 14 of the compilation which you have given.
Yes, compilation. I have given two compilation. In one compilation, there is orders. In one compilation, there is applications.
I have not got two compilations with me.
No, that is already
supplied me with one compilation.
That is their petition only. That is their petition filed by CRLMC number 1763.
Whose petition? You should supply a copy
No,
of
your
that.
petition. You have filed it.
It may be my petition.
No, there was a
but
judicial
copy of
direction.
it.
No, there was a judicial. Sir,
where is the
sir,
have you served
there
a
was a
copy of
judicial
it or
direction. There was a judicial direction. You were supposed to supply it.
Which one?
Please read the order. The order
Yes.
which I read.
Read that.
As
14.
you did not supply, I had to file it.
What does the order say?
I just read the order now. Order dated 21/3/2024.
I am.
Yes, Poduchi. Mr. Panda, learned counsel for the petitioner, seeks time to
I
file
am.
an illustrative chart and would make endeavor to place on record order dated 29/4/2011 by the next date. As you did not place it, I placed it. It is already with you. I am just placing it.
No, it is not there with me.
But you should have told me it is not there with you.
Not there
Yes.
with me in this
Now,
brief.
your Lordships may kindly come to
I've given a
CRLMC number
copy of that.
1763 of 2011. Now, your Lordships, annexure, page 14, straight, your Lordships. Interlink Private Limited has filed this application under 239 CRPC for discharge. It appears that this court framed charges against the firm on such and such date. Now, your Lordships, it is an exhaustive order of 5 pages, in which I would like to read page 17, which is the operating part of the order. Your Lordships has that?
Yes, I got it. I read it
Peruse the
out.
case record. Law is well settled that at the stage of the framing of the charges, the court is required to evaluate the material and documents on record with a view to finding out if the facts shows the existence of all ingredients constituting the alleged offense. The court may, for this limited purpose, if the evidence such and such. Thus, provisions of the Act confer special power of the judge to discharge the accused if, upon consideration of the record documents, he considers that there is not sufficient ground for proceeding against the accused. In other words, his consideration of the record and documents at the stage is limited purpose of ascertaining whether or not there exists sufficient ground for proceeding against the trial, against the accused. It must be remembered that this section was introduced to avoid such and such. Considering the case, it is seen that put up these frame charges against Surendranath interlinked. The prayer has been rejected. After that, your lordship, they filed on CRLMC. Now, your lordships, I will give the orders of the CRLMC. What happened to the CRLMC, your lordships?
Yes.
Lordship may kindly come to the first order, that is order dated 6/11/2011.
Six
2011 to 6/11/2021, your lordships.
Where is that? In the order compilation.
Order compilation, your lordships.
Yes.
In that, your lordships.
Page
1, your lordships.
Yes.
Page 1, your lordships. The CRLMC is dismissed for non-prosecution.
Yes.
Then, your lordship, there is an order dated 25/3/2022, which I could not get in the internet.
Yes.
But your lordships, the other compilation which I have given your lordships, in which there are petitions, your lordships, in page 25 of the other petition, your lordships.
Page 25.
That order has been annexed by them. Page 25 of the other compilation.
Hmm.
When they
Yes.
have filed a CRLMA, the court held that the court is of the view that the petitioner is a recalcitrant litigant and does not want to proceed with the matter. Hence, the CRLMC stands dismissed. Now, lordship, this is the second dismissal. That is on 25/3/2022. Now, your lordships may kindly come to another order dated 21/12/2021. One Rajdeepa Beura appeared, your lordships, from Delhi. The court held that considering the submission, interim order dated 26/2011 is restored and shall continue till 2022. That means, your lordships, when
the one which was dismissed in default and restored.
Yes, the order which was challenged, your lordship, the dismissal of the discharge application, which was challenged before this honorable court, notice was issued, stay was granted, and that stay continued for 10 years, and the matter was heard. After it was restored, your lordship may kindly come to order dated 25/11/2021.
25/11, yes.
Yes. Considering the submission advanced by the learned counsel for the petitioner, the prayer is allowed and the CRMC is restored to the original number.
Yes. Yes.
After it was restored, your lordships, again it was listed on 5/5/2022. Because, your lordships, again it was dismissed for non-prosecution. 5/5/2022, lordships, is very, very crucial order. 5/5/22, one Vidyalok Mahapatra appeared for the petitioner. The court is saying that it appears that the CRLMC was dismissed for non-prosecution, video order dated such and such. However, on the prayer made, the same was restored, video order dated such and such. Again, when no one appeared on behalf of the petition on the date fixed, the case was dismissed. Mr. Vidyalok Mahapatra, learned counsel, appearing for made such and such submissions. I am not inclined to do so, as this is the second default of the petitioner. Hence, CRLMA is dismissed, but liberty is given to the petitioner to approach this court if cause of action survives by filing a fresh petition. Then he again filed a fresh petition, your lordships.
Yes.
The order in the fresh petition, your lordships, is order dated 22/9/2022.
Yes.
The fresh petition which he filed, in that fresh petition, it is written that the application for restoration of CRLMC, which was dismissed for non-prosecution, video order dated 25/March/2022, in view of the order passed dated 5/March/2022, passed by the court in CRLMA, I am not inclined to entertain the prayer.
Yes.
That means,
Yes.
your lordship, the liberty which was granted, if cause of action survives, that liberty was taken and this liberty was rejected. Then they filed another CRLMA. CRLMA number 5 CRLMAs were filed, your lordships.
Yes.
Now, this CRLMA, they took all the ground that liberty was given. We went and it was rejected. Now, your lordship, the main order, which they have shown before the trial court, is at page 13.
Yes.
Now, page 13, your lordship, is very, very crucial, in which the argument of sir and my arguments are recorded.
Yes.
Then, your lordship, I'll go to the finding. Mr. D. Panda, learned senior counsel for the petitioner, while praying to withdraw the CRLMA, submits that since this court by an order passed on 5/5/2022 in CRLMA number such and such had granted liberty to the petitioner to approach this court if cause of action survives by filing a fresh petition, the petitioner may kindly be permitted to agitate this grievance against again before the trial court. This is the submission made. This is not the finding. My submission was recorded. Mr. Sarthak Naik, Learned Counsel for CBI, however, strongly opposes such prayer of the Learned Counsel by inter alia stating that such prayer is not maintainable in the eyes of law.
Yes.
Now, your lordships, in view of the aforesaid submissions, this court, without making any observation of the merits of the case, allows the petitioner to withdraw the CRLMA. But where the liberty is given to agitate, re-agitate it again before the lower court, no such order has been passed, your lordships. But this order was shown before the lower court and got interpreted as if the court has given the liberty to go there and re-agitate the issues and pass a second discharge application, your lordships, which this order never says, your lordships. Therefore, the order of the first
against that second discharge application which was turned down, now the present petition
it is not
filed.
maintainable, your lordship. That is a direct judgment of this.
Hey,
there is a direct judgment, your lordships.
Yes.
There is a direct judgment. Vipin Chandra Dikshit, your lordship. Second discharge application is not maintainable, your lordships. And
Yes.
court never allowed, gave this liberty, your lordships. The court only said that in view of the aforesaid submission, this court, without making any observation on the merits of the case, allowed the petitioner to withdraw the CRLMA. So it was withdrawn. That means the first discharge application, which was rejected before the lower court, which was challenged before this honorable court, and it was not restored since last 6 attempts, and in which notice was issued and they enjoyed the stay, has attained finality, your lordships. And there is a direct judgment, your lordship. Second discharge application is not applicable. This judgment dated criminal revision number 2056 of 2023. Your lordship may kindly read.
Yes.
It is only a 2-page order, your lordships.
Have you pointed out this
Yes,
fact
yes.
in trial court?
Your lordships.
Have
Trial court
you
has,
pointed-
trial court has passed and your lordship may kindly read the trial court order. There is no need to point out before the trial court because the trial court himself has passed the discharge order and trial court has said that that would amount to your lordship like reviewing the own order. Lordship may kindly read the trial court order.
Yes. Where is that?
Operating part of the trial court order, which sir is challenging. Lordship may kindly come to the trial court order.
Yes.
Trial court order which is being challenged, your lordships. Last paragraph, your lordship may read page 18 to 19.
Yes.
In the present case, the earlier petition filed by the accused petitioner under 239 was rejected by this court, and the same order is in force. Further, for the case record documents, it is found that there is prima facie material sufficient ground for proceeding against the accused. Considering the present facts and circumstances of the case, this comes to the conclusion that the present petitioner inter leg accused number 7 represented through cannot be discharged.
Yes, I am. Yes.
Lordship, therefore,
You see, the, 2 compilation you have given. Can you please give in a sequence?
I've given in sequence. One is only the orders.
No. Please, please prepare a note and give the sequence because
Let
very
me
difficult.
read this judgment, your lordships. 2 minutes.
I read it.
No, your lordship, sir also needs to read it.
Second-
Submission of the learned counsel for the opposite party. Only 2 minutes, your lordships. It is submitted by the learned counsel for the opposite party number 2 that the discharge application filed by the revisionist was already dismissed on merits. Video order dated such and such. The criminal revision preferred by the revisionist was also dismissed on merits by order dated such and such and has attained finality. Considering the submission of the learned counsel for the opposite party number 2 on perusal of the record, it is apparent that discharge application filed by the revisionist was already dismissed by the court. By the revision is also dismissed. Therefore, second discharge application on behalf of the revisionist is not maintainable. The trial court has rightly rejected the discharge application being second discharge application moved on behalf of the revisionist. There is no illegality in the order passed by the learned trial court. Direct judgment, your lordships.
Without there being any liberty. First.
Yes, yes. And this was after notice matter, your lordships.
Okay, I'll pass you.
Yes.
Okay.
Here my submission is this, my lords. My submission is that in CRLMA 78 of 2022, a liberty was granted to petitioner to approach this court if cause of action survived. And because cause of action survived, my lords, the petitioner, while withdrawing the CRLMA, referred to that submission and thereafter approached the trial court. Now, when the petitioner approached the trial court once again, my lords, the petitioner stated all facts, my lords, and it was brought to the notice of the court that earlier, my lords,
Now charge has been framed?
No, it
No,
has
it is
not
fixed for the
been framed.
framing of charges.
My submission is this, my lords. A petition for discharge was rejected, against which, my lords, a revision was filed in this court, my lords. This court dismissed that revision for non-prosecution. And not on merits, my lords. Having dismissed it for non-prosecution, having restored it and again dismissed it, this court was not inclined to hear the matter on merits. But Justice Pujari said in CRLMA 78 that if the cause of action survives, the petitioner may approach this court. Having said this, my lords, the petitioner placed that in the subsequent CRLMA and moved the trial court, my lords. So it is not a second application for discharge as is being contended by my learned.
Now, your lordships, the order
My
was passed.
submission is that
I got it. There is.
What was decided by the court below, my lord,
Yes.
was not affirmed by this.
You people can give 1 page, 2 page note. Yes, I'll pass.
Your
Yes,
lordship,
next.
it was dismissed for your lordship, it was
I got it.
Like, non-count.
It was dismissed after notice. After notice, if matters were heard and argued, enjoyed stayed for 10 years, then it was dismissed, your lordships.
Yes, for non-prosecution.
And your lordships, 22/9/2022 order that liberty was already taken if cause of action survived. They filed another application, it got rejected.
I got it. Yes, next.
Yes.
You file short note.
Yes.
24. The interim order may continue
Yes.
till delivery of.
In this particular matter, my lordship was pleased to pass an order on 24/11/23. My lordship would very carefully hear this matter. Why?
24.
My lordship's order is 24/11/23.
Generally, I do. I'm trying to do it.
No, my lords, why I say so?
Carefully.
No, while arguing why I say so, my lordship's order was under challenge before the division bench. It is for the hearing of this bench and the court. The lordships, the acting chief justice and the brother judge said there could not have been a more erudite, more beautiful and more explanatory with a legal acumen, could not have pronounced it any further. And gave its reasoning, I still echoes in my mind, paragraph 16, 19 and 21. Where my lordships categorically stated, and while stating, made a small remark saying Mr. Ray has also brought it to my notice that a person born by birth, whose father is also retired as a Pano, shall continue as a Pano.
Why are you not complying?
No, that is not, my lordship, one more minute. Then my lordship, see the last page of the application.
Your application.
The last page of the 200, the contempt application.
Yes.
Page number 20.
20.
Page number 20. And the court gave 6 weeks time saying if you do not comply, it will be stipulated as a deliberate contempt.
Where is that?
Page 20.
The past contempt.
Page 20.
No, first contempt. Eighth contempt.
Eighth contempt.
First contempt disposal.
My lord said, it will make clear that even the order is not given effect to within the time stipulated herein above, it will be construed to be a deliberate violation of this court.
Where are you reading? I am not.
And there was no stay in the writ appeal. My lordship, page 20, last page of the my contempt application.
Yes.
Order of a coordinate bench.
Yes. Considering the submission, para 3. Para 3, considering the submission.
Yes.
And
My
last
lordship
opportunity
says
you granted to
it
provide
is
the last
made
chance
clear.
to content. Yes, Mr.
Now, my lordship, one more minute, my lords. Why I say so? 23 to my lordship passed. Order has not been complied. Another coordinate bench said again 6 weeks time. Order not complied. Can it be more heinous than this? When we went with the second order of the division bench, they said let them keep passing orders. This was a remark given to a Pano who was a classmate Pano, does not understand much English. He said, Tamar kamate me kadyo. We will see when we will implement. Is that an attitude? Should this not be a deliberate contempt, my lords? And should they not be taken to task?
My lord, in the meantime, the writ appeal has been prepared before the division bench. And I got information that writ appeal has been disposed of just 24 February 2025.
So the mayor filing up for the writ appeal without stay is of no consequence. There is an order. See, my order is very clear. I said forthwith. Thereafter, the contempt court gives you 6 weeks. Okay, it's all right. Even according to me, contempt court should not have also given you. Fourth is fourth.
Right.
While exercising contempt jurisdiction, the time granted by the original court cannot be extended.
Correct.
I said forthwith means forthwith. Nothing can be added in a contempt jurisdiction. It has to be complied. Simple. Will you do it within 1 week, or I'll summon
my lordship
the contempt to appear in the person?
More than 1.5.
No. Report it on 12 or summon.
Yes. About that.
You can't see the High Court orders cannot be taken so lightly.
Taken so lightly, my lords.
After
No.
You lost the appeal also.
My lords.
Lost the appeal. Then what else? Why should you wait? Comply. I'll record your statement that within 1 week we are complying.
Yes, bow down. Deeply obliged. No. Why 2 weeks?
You comply.
Half years.
Thereafter, what you will do, you know, after 2 weeks, you file an SLP, come with a diary number. And that SLP will remain for 2 years. Thereafter, a review dismiss. Thereafter, a review petition. Another diary number. We will go on and on and on.
Poor, illiterate.
Either you give or don't give.
Yes.
You say that I will not give, then the court will take its own course, whatever.
My lordship would observe.
Right. The present contempt petition is has been filed by the petitioner for deliberate non-compliance of the judgment of this court dated 29/9/2023, passed in WPC number 36822/2022. Earlier, the petitioner had moved a contempt petition number 9029/2023, seeking compliance of the aforementioned judgment. The coordinate bench of this court wide order dated, what is the order? Sealed 24/11/2023 has passed the following order. Para 3. Page 20. Para 3. When the aforementioned contempt petition number 9029/2023 was being heard, at that point in time, the judgment of this court sought to be complied was under challenge before the division bench of this court in WA number
1228 2024.
228.
1228.
2028. Mr. Biswal and Counsel for the State submits that the said appeal has also been dismissed.
Yes.
Wide order dated
24th February 2025.
24th February 2024. After the hence the judgment of this court dated 29/9/2023 in writ petition number so and so have attained finality. In these circumstances, there is no other option left for the petitioner. In these circumstances, it is obligatory on the part of the contender to comply the judgment forthwith. Mr. Biswal, the counsel for the petitioner, seeks a week's time to comply the judgment, and furnish a report before this court. Lease the matter on 20th of this month. Yes. You eventually got 2 weeks only.
My lord.
At 20th, I am receiving.
My lord.
In the comment, what happens?
May I say something, my lord? My lordship is the star of this High Court.
Thank
No,
you.
my lord. I have to tell my lordship. I have to make, because I am good ODR Nishwas Supere Vishwas Nahi. But all that I can say, This High Court is privileged to have my lordship as a judge.
Thank you. Thank you very
And
much.
I have known my lordship while arguing before the Supreme Court. They could not have been fairer counsel than my lordship. But this is what my heart says so. This is not modern flattery. This is what is actually fact, and my lordship deserves it. And a long way to go, my lords.
I had also having the privilege of facing you.
And my lordship,
difficult opponents.
this is not, they say two heads are better than one. What the division bench, after going through my lordship judgment, stated, there could not have been a more erudite, brilliant judgment like this, is what the court openly stated. So this gave me so much of pleasure.
Now what the division bench says is not more important. What the state does is more important. Yes.
May I say something? Failing which, stringent action will be taken. One word, my lordship. My
20th, I'm keeping it 1 week time, I'm giving it.
No, my lordship would only write that. Then one word there.
Non-compliance of the order. Better you see. In fact, in such situation, notice has to be issued. There are in a contempt jurisdiction 2 notices has to be issued.
Correct.
Notice on the contempt and the framing of the notice.
Correct. Agreed.
And if the order is not complied within a week, on the next date of hearing, the notice would be framed for the purpose of initiation of contempt.
Wow.
I'll have to frame the notice on the next date. Wow. Yes. Let us see.
Yes. Item 25. In sub-item, my lord, I am before your lordship in sub-item, and your lordship was pleased to have this matter and was perused the affidavit which has already been filed by the SP and pointed out that paragraph 9 and 10. And at that time, your lordship asked for the presence of the present petitioners, but due to the law and order situation, she was not there. For that reason, it was adjourned to today. Is my lord petitioner is present?
Let us see the first petition.
Yes. That affidavit, my lord.
Yes.
Your lordship has already perused that affidavit, paragraph 9 and 10.
You are talking about the second matter?
Yes, my lord. I am second matter.
Yes.
And have a glance to this the affidavit, my lord, paragraph 9 and 10.
Not affidavit.
I said that is the report, my lord. Sorry, report, my lord. Report
yes.
filed by the.
Have you read it? I told
yes,
you.
yes, my lord.
Yes. The last paragraph is coming to your rescue. That's
for that reason.
Yes. Yes. Regarding the litigation made in the product Yes.
Yes, sir. I have gone from that 9 and
10.
Paragraph 10 and 11. This is the SP gives the report.
SP's.
The complaint. This is about the second matter or first matter?
Second matter.
Second.
Whatever the first matter.
First matter, I have no power, my lord. I have.
Okay, first matter we'll see. Second matter let us finish. Okay. Let us. At the influence of opposite party number 2, FIR number so and so came to be registered against the petitioner. Allegation against the petitioner is so and so. What is the stage? Charge sheet is in
No, my lord. Charge sheet has
when
not.
the investigation in the present case is still going on. At this stage, the petitioner and the opposite party have entered into a settlement. On the basis of settlement term, the present petition has been filed. The petitioner and the opposite parties, both the opposite party, are present. In opposite party being informant and victim are present in the court, being represented by their respective counsel, identified by them. They've also filed self-attested copies of their Aadhaar card to establish their identity, which are taken on record. The matter was taken up for hearing on 21/1/2025. and the following order was passed. Okay, following order was passed. Pursuant to the said order, the Superintendent of Police Kendrapada has now filed an report, status report. In the status report, the relevant would be to produce para 9, 10, and 11. 9, 10, and 11. The report reveals that the complainant injured, although was admitted to the hospital, but during his treatment, he has not made any allegation against the present petitioner. This court was examining as to whether any custodial torture is committed by the present petitioner, who is working as
at present, my lord, DSP.
no, that time
IIC Marsaghai PS.
Who was IIC
Marsaghai PS.
Which PS?
Marsaghai PS, District Kendrapada.
Marsaghai PS. Since the petitioner is an police officer and the allegations are made against him that he has tortured he has beaten up the informant in the while in custody in the police station. Therefore, it was necessitated for this court to pass the order dated 21/1/2025. Subsequent thereto, pursuant thereto, the Superintendent of Police has filed the status report. While the matter stood thus, the parties have entered into a settlement, and the opposite party number 2, opposite party number 2 has filed an affidavit before this court dated. What is the date of affidavit? Dated. Dated 20 October 2024. 20 October 2024. Inter alia stating as under para 1 to 5. Para 1 to 5. Para 1 to 5. The informant opposite party number 2, who is present in the court on the query from the court, who is the Manoranjan Dalai? Manoranjan Dalai? Ki? Who is Manoranjan? अब ना कौन आप केस कहीं फाइल करते केस कहीं फाइल करते हाँ कौन हला आपण मिछरे करथिले आपण मिछरे केस करथिले मिछरे केस कला परे कोन हुई जानछन तो मिछर केस कौन पाई करथिले कोन घटना सत घटना कोन हितला कोंतु
इन्फॉर्मेंट होतन कादम्बिनी
किछि डरिवार नै मु क्वास करबी किछि करिवार नै आपण कोन सत हितला कोन
कादम्बिनी
सत कोन हितला कोंतु मु क्वास करबी किछि करिवार नै सत कोन हितला कोंतु आपण को आईआईसी मिसबिहेव करथिले थाना रे मिसबिहेव करथिले करनांत ताले आपण अगेंस्ट केस फाइल करियो रजिस्टर करियो सत कोंतु डरिवार नै किछि कोंतु मु केस खत्म कर देबी किछि असुविधा नै कि जानिया चाहू what exactly they have to happen, because I have to impose some cost depending upon the gravity of allegation. I will quash it. I am going to quash it. I am pass the order, but in order to decide some cost, maybe a token cost, whether exactly, see, he might have been terrified by the officer,
no,
or he might have falsely implicated the officer. Both the things are possible. The SP says that the
falsely implicated.
false. So it may so happen the officer is victimized by this man. You never know. Both the things are possible. So I want to know exactly what had happened.
ଗାଁ ଗଣ୍ଡାରେ ଆଜ୍ଞା ଟିକେ କାହାର କଣ ସ୍ୱାର୍ଥରେ ଆଞ୍ଚ ଆସିଲେ ସେ ଆଜ୍ଞା ଭୟଙ୍କର ହେଇଯାଆନ୍ତି ଆଉ ବିଭିନ୍ନ ନାଷ୍ଟି ପଲିଟିକ୍ସ
ଏଇ ଘଟଣାରେ କଣ ହେଇଥିଲା? ସତରେ ହେଇଥିଲା
ଇଏ
କି ସତରେ ହେଇନଥିଲା?
ନାଇଁ ସତରେ ହେଇନଥିଲା ତାକୁ ମିଡିଆ ବୋଲା ଆଜ୍ଞା
appearing informant, his wife.
wife is the
He is the
informant wife
She may
ask her.
ହଁ ଆସି ହେଇଯାଇଥିଲା
ଆପଣ ଟିକେ ଏପଟେ ଆସନ୍ତୁ। ହଁ ଆପଣ ଆସନ୍ତୁ।
ହଁ
Just I am causing it. Don't worry about it.
ଆଜ୍ଞା ନାଇଁ ନାଇଁ
I'm not going to do it, but just I want to know. And who has filed this? Who is the informant?
My lord. I am appearing.
No, who is the informant? Name?
Informant is the
Kadambini ଆଜ୍ଞା
And then why Monoranjan has filed affidavit?
One of the big injured me.
ଦି ଜଣ ଫାଇଲ କରିଛନ୍ତି injured plus
And
informant
where is her affidavit? The Monoranjan Dalai, who is the victim in the case.
ଦିଟା affidavit ଆଜ୍ଞା ଫାଇଲ
Where is the affidavit? Her affidavit? The informant, Kadambini Behera.
Kadambini ଯୋଉଟା joint ଜ୍ୟୋତି joint
Both are jointly taken.
Okay. No, who is the informant? Who is the victim?
Informant is Kadambini Behera.
Kadambini Behera, who is the informant in the present case, has also filed a separate affidavit with the same date. She also reiterated the same thing. Reiterated the same, and in her affidavit, she inter alia has stated as under para 1 to so and so, para 1 to so and so. Mr. Vishal agrees for the state and submits that the FIR is at the investigating stage. The parties have settled their dispute. Informant as well as the victim have separately filed the affidavit. Separately. The Superintendent of Police, Chandrapura, whatever, Chandrapura, has preliminarily investigated the matter and found it to be the facts are found the fact not to be true. Regarding being head to the same, there is no legal impediment in questioning the FIR. I have taken into I have taken into consideration the all the fact scenario of the present case and attending circumstances of the case, and of the considered view that subjecting the petitioner, who is a police officer, to the rigors of the trial in the present facts of the case would be a futile exercise, and it may have an impact in his service career as well. Therefore, I am inclined to allow the petition and quash the proceeding, quash the FIR and consequential proceeding arising therefore. What? Yes, Mr. Bishop, whatever.
See, they told that nothing has happened.
The problem, 10,000, subject to paying 10,000 cost. Something has happened, I know.
10,000 mail or petitioner ଦେବେ
petitioner they pay to
ଏମାନଙ୍କୁ ତ
yes
ଆଜ୍ଞା ଆମେ ମେମୋ କରିକି ଦେଇ ଦଉଛୁ ଆଜ୍ଞା
this is a token only
ଆଜ୍ଞା
because they might be terrified also
ଆଜ୍ଞା
yes was it okay. And in so far as the first matter is concerned, I'll just adjourn it today. It may be so it may the prejudice may work. Okay, so I'll just simply adjourn. Okay,
17th.
Second matter ta kar diyo. First matter
may kindly put on 17th.
17th nahi ta par say 17th wala week dekhi dejiye.
Small prayer my lord. ଆମେ 10,000 ଟଙ୍କା ଦେଇ ଦଉଛନ୍ତି କୋର୍ସ ଅଫ ଦ ଡେ କିନ୍ତୁ ଅର୍ଡରରେ ସେ 10,000 ଟଙ୍କାଟା ରହିଲେ ତାଙ୍କର ସର୍ଭିସ କ୍ୟାରିୟର ଫ୍ୟୁଚର ଟିକେ ପ୍ରୋବ୍ଲେମ କାଳେ ହବ ସେଇଥିପାଇଁ ସେଇଟା ନରୁ ଆମେ ଦେଇ ଦଉଛୁ ମେମୋ ଦେଇ ଦଉଛୁ ତମକୁ ଦେଇ ଦଉଛୁ.
Then if that is the case, pay 20,000 rupees. I will not write.
10,000 to
20,000. Pay 20,000 to remove that. 20,000 give this. Show me the receipt.
15,000.
20,000 you pay. I'll be increasing.
ଆଜ୍ଞା ଠିକ ଅଛି.
Pay 20,000.
Bar association.
See, I tell you, these people are maybe terrified because he is a police senior police officer. So at the same time, his career will be affected unless he has paid cost.
ठीक है ଆମେ ଦେଇ ଦଉଛୁ ଆଜ୍ଞା ଅର୍ଡର ସିଟ୍ ରେ
20,000 rupees ଦିଅ order 20,000 କାଟି ଦିଅ.
okay
Yes.
26.
Yes.
Lordship, the last date before the learned counsel for the opposite that 1CC case has already been over. But my lord, to that extent, I have obtained instruction, the certified copy of the order sheet that the matter has been adjourned to. I have obtained the the matter has been adjourned to 4/9/2025 for.
Where is, you are supposed to,
My lord.
oh,
I-
you are
Yes, my lord. I am
supposed to place on record
My lord,
the.
I am filing it today.
Yes, on miscommunication, my statement was there. But
You said
because
concluded.
because of the fact that the proceeding has been stayed by this Hon'Ble court, that is pending.
Okay, pursuant to the
Subsequently, I inquired.
5/2/2025, the Learned Counsel thought the petitioner seeks to file an additional affidavit. Additional affidavit. She hands up for the additional affidavit in the court. However, court. She is permitted to file the same in the registry during the course of the day, release the matter, and interim order to continue. Yes.
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 Obliged.
For the
28 after which.
which, yes.
29.
कितने टोटल मीटर था टोटल मीटर कितने 29 huh? Chapter matter all hearing matters. Yes.
Small note for a lordship clarification.
Hearing. Are you ready? Are you ready?
My lord, 1 minute. Item 28, I am object party. They gonna mention kari kaisi after 2 PM now. No election charge rachi 2 PM out of date. Mate information date twist kare.
28 adjourned kar diya. That's very important. Nobody can stop it. Yes, 28 adjourned kar diya. 29, are you ready for hearing?
Yes.
Then I'll hear it up.
Yes.
2 o'clock.
Time for the petition.
Yes. Next 30.
Yeah, 31.
31.
After post lunch, your lordship.
Let me see. Post lunch only now. Can you finish within 2-3 minutes? Then I'll hear.
No,
Then 31.
My lord's lunch is not over, so it cannot be post lunch.
Yes.
My lord, 31 I am for the petitioner. Notice has been notice for the opposite better.
You have appeared?
Yes.
What do you say? Hearing?
I'm ready for hearing.
One adjournment,
Shown to entered appearance on behalf of opposite party, seeks an adjournment to file response to the petition. And the interim arrangement made on 30th January 2025 shall continue.
My lord, adjournment.
I've given that, he'll give a date.
My lord, then I have small prayer, my lord. Here they are asking for adjournment, and on Learned Court below they are asking.
No, I have given that direction. You will move application for
Obliged.
Yes. 32.
Compromise between the parties. My lord, allegation is 306. And the charge sheet has already been filed. From the charge sheet, it is revealed that she was a bad-tempered girl for which she committed suicide. Now the parents are already, they are in good terms and they have decided to not to proceed with the case.
Can it be done? 306.
In view of the
Do you have any?
Yes, in view of the Gyan Singh's case, your lordship can do that.
Gyan Singh, apart from Gyan Singh, 306, do you have any?
My lord, 306, Gyan Singh case also, it is there.
It's a 306.
No, they have enumerated where it is can be done. Para 57.
I'll issue notice then, let us see.
No, they have already entered appearance. We have already filed, the parties have already filed their respective affidavit and they are also present today. Because there is a small boy of about 9 months who is.
Where in the charge sheet has it come?
Yes, yes. Charge sheet, your lordship may kindly, that will clarify.
On the merit you will be discharged.
My lord, your lordship may kindly see the charge sheet. That will do everything. Your lordship may kindly turn to page 24.
24, yes.
24.
Temper.
But
Temper personality.
my lord,
Tempered personality, short-tempered personality.
but the marriage
I've seen it.
was a quarrel. Yes. For which, for trivial issues, she committed suicide. Why her child had
Then keep it because the parties has to be there. If it is
parties
compromised,
are there. Parties are there.
just see
304.
304,
80 plus subclause 2 means my lord 304 B my lord. Dowry death.
My lord, dowry death, my lord, your lordship may kindly
The
see.
material has to be examined.
Material कौन examine करिबो? So, material has to be
नहीं,
examined.
304
नहीं, ମୁଁ कहि दउछि. Your lordship may kindly, what purpose shall be served? That is the purpose of trial. The lordship may just, I am placing.
Your lordship target the
No,
that part I know. Gyan Singh, that part.
yes, that is very clear, my lord.
It is against the society and all that also has to be taken.
That should be taken
Moral
note of.
turpitude has to
But
be
in
taken
this
into
case, what has happened, the father has also stated that she was a ill-tempered lady. And for trivial issues, she quarreled with everybody. Why her child was...
Then I'll take it up at 2 o'clock.
At 2 o'clock. Okay.
25 of 2025 regarding release of interim release of my passport. I argued that matter on Tuesday last.
Within half an hour or so, it will be uploaded.
My lord, and one request, my lord, your lordship may direct the trial court to act upon the uploaded order. Because
I have already passed the order. It will be uploaded now. I'll sign it.
Obliged.
Yes.
Obliged.
May I please, your lordship? May I please, your lordship? Your lordship, may kindly see the first order where your lordship had issued notice and granted stay of the proceedings, my lord.
Yes. Yes.
This application is, my lord, challenging the criminal proceeding under 138 of the Negotiable Instruments Act. It is challenged on specifically on 2 grounds, my lord. Number 1 is that the company on whose behalf the checks were issued have not been arrayed as a party. Second point is, if your lordship sees the checks, 2 signatories are there. Only 1 signatory has been made an accused, and no notice has been issued to the other accused, nor to the company.
Show me the check.
My lord.
Yes, I got it. There are 2 directors.
My lord, there are 2 directors. It's at page 18, my lord.
It's not right.
18, 20, and 22.
Okay. I got it. Yes. TSL means TSL Spring City. What is it? Address?
But
Director of what?
TSL means Krishna Skyscrapers Limited.
Who is appearing?
My lord, I am there.
Just come to page 18. Your complaint.
I have seen it. My lord, let my senior finish.
You answer it.
Yes.
See, there are 2 signatory, 2 directors have signed.
Yes.
And the company is not made party.
Yes.
And even directors are not made party.
Yes.
Just see, come to number 2 column.
My lord, I am coming.
Yes. Satyanarayan Dhir, age about so-and-so.
Dhir.
And owner come director TSL Spring City. What is this?
Yes. My lord, may kindly see what is the prayer.
Yes.
Prayer is to quash the cognizance order dated 21/3/2015 So 2015 order is being assailed before your lordship in 2024. What is the explanation has been provided in the CRLMC petition? There is zero explanation. Second, the complaint petition has been filed against Satyabrata Dheer. Page 15.
Yes.
Owner cum director TSL Spring City Bhubaneswar.
Yes.
What is the check? Check is 27/6/14 dated 3 checks.
But Krishna Skypacker Limited has issued.
Yes. This
That
check,
is TSL.
TSL.
That is TSL.
TSL is under challenge. First, my lord, from 2014 to 2024, what they were doing.
Yes.
When I issued the first notice under the NI Act.
Show me the NI Act notice.
Yes.
At page 29, my lord.
Yes.
30.
Yes.
This notice was given.
Yes. To
you being the director of TSL.
To Satyabrata Dheer.
Yes.
Yes.
My lord, I cannot now change it. What is there is there. Paragraph 2. You being the director of TSL Spring City Bhubaneswar, you issued allotment order number such and such, allotting flat number such and such. The indenture of the agreement was executed in the director of TSL Spring and my client for both the flats separately on such and such.
That yes, in the capacity of director. What is the reply?
Yes. No reply.
No replies.
Then
No
139 operates against you.
My lord, presumption how, my lord?
Notice was given on the capacity of a director.
My lord, if you
now you can put your case to the best.
My lord, your lordship will see, my lord.
Yes.
The notice has been issued to Satyabrata Dheer in his individual capacity.
No, see the
and what about the notice, my lord, to the other co-signatory?
It's not. You show me any judgment. If a company has issued a check,
my lord, I'll
two directors have signed.
I'll just show, my lord. I have filed a return.
Both the directors have to be made party. One director is sufficient.
The notice has been
and without director, if the company is prosecuted, then you have a case.
Yes, my lord. That's my case. That's the second limb of my argument, my lord.
But the company
has not been made an accused.
But the director is prosecuted.
Director is only one. There are two signatories. Two directors have signed. Now, if your lordship says, my lord, I have filed a small note for your lordship's appreciation. And I have.
But why have you come? See, the 138 case is going on since 2000.
My lord, complaint is not maintainable. I am raising the maintainability now, my lord. And it can be raised at any stage of the proceeding, my lord.
My lord,
I am raising the maintainability of the complaint, saying that the director the company on whose behalf the checks were issued.
Within 6 months, this type of complaints should have been disposed of.
Should have been disposed
after about.
But unfortunately, my lord, it has taken a long time.
In order.
Your lordship may kindly see the note
and you allow the proceeding to go on for such a long time.
And this point is no more receding, my lord. It has been decided by the Honorable Supreme Court.
What is the stage now? What is the stage?
Stage, my lord, the evidence is over. Complainant's evidence is over.
And
at that stage, I have come.
Well, I'll keep it open. You address it this last stage.
My lord, complaint is not maintainable.
That's right, but you allowed it to go on for a decade.
Lordship,
you should have come at the first instance. 2015. Just imagine 138 matter.
Maybe, my lord.
138 matter.
I bowed on matter. 2015, I bowed on. But fact remains, my lord, your lordship has to see. Your lordship has to see, my lord, whether the complaint is maintainable at all. If it is not maintainable, why should
have you moved any application before trial court?
But where is the stage? Where is the stage I should move an application?
Stage is when cognizance is taken.
No, my lord. That stage, my lord, the accused is not being heard.
2015 cognizance.
It has not been heard, my lord. The accused is not being heard. And if your lordship sees, my lord, Anita Hada's case, my lord.
If you allow a proceeding to go on for a decade,
my lord,
and after a decade, not a decade, more than
change of hands, my lord,
and at the stage scuttling the trial at the fake end, is it permissible?
My lord,
show me any judgment.
May be permissible, my lord.
Show me any judgment.
My lord.
My lord, may kindly
My lord,
come
this-
to
1 minute, let him complete.
Yes.
Yes.
My lord, so far as these two issues are concerned, my lord, these two issues are no more rescinding. The first judgment is of, my lord, your lordship had a privilege to appear in that case, my lord. That is,
Which one?
Charanjit Pal Jindal versus LN Metallics.
I was appearing there. Yes.
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 And the same arguments were put for
There, in that case, after conviction. And the
It was after
there.
conviction. It was after conviction, but the law has been decided, my lord. Now, my lord, in that case, relying upon the judgment of Anita Hada's case, my lord, the Honorable Apex Court at paragraph 9, 10, and 11.
Yes.
I'll just read out if your lordship permits me.
Yes.
In Anita Hada's case, the question that arose for determination by this court was whether an authorized signatory of a company would be liable for prosecution under section 138 of the Act without the company being arraigned as an accused.
I know that Anita Hada is very clear.
My lord, that is very clear. Now, second judgment, my lord, may I complete that, my lord? That is, in 53 of the said judgment, my lord, in Anita Hada's case, paragraph 53, it is to be borne in mind that section 141 of the Act is concerned with the offence of the company. It makes the other persons vicariously liable for commission of an offence on the part of the company.
Yes,
as has been
there. That's there.
And paragraph 59, where
What is the check amount?
There are three checks, my lord.
5 lakhs or
5 lakhs, 5 lakhs, 650. 640.
Have you filed recovery suit? No. That also goes. You are in very difficult position.
My lord, may kindly see the prayer.
Sorry.
No, the prayer is all right. See, what I tell you in that metallics, LN metallics case,
My lord, I had
the earlier regime was without company also you can prosecute the director. When the complaint was filed, the conviction was secured against the director. And then the law changed, Anita Hada came. And whether that judgment is having a retrospective effect or not, that was the question.
That was the
court said nothing to you. Now the position of law is this, so the acquittal goes, the conviction goes.
My lord, I had argued Lalit Beriwal case, which
I'll be-
But Anita Hada
case was also argued by me in, not in.
He has changed stance now.
Obviously.
But Anita Honda holds the field.
Yes.
Even if I
was also relied upon.
like, but I appreciate one thing. Even if I dismiss it, saying on the ground of delay, eventually he is going to be acquitted.
That is
That is Gyan Singh. Gyan Singh says that you have to test it. 14 years, 1 decade, the court's time has been wasted by him. No doubt about it. And why should the court, while exercising 482, again allow a proceeding to go on, which is likely to be a futile exercise?
My lord, what?
That is the
notice
When the
was given,
chances of conviction, when the chance
given. My lord, your lordship in sitting in 482 will not decide whether the conviction will be there or not, or there will be an acquittal or not.
If there is apparently this is very apparent what to do.
Complete. When I first issued the notice, was it not on his part to reply the same that the company has not
The best thing what I can do is I have to impose heavy cost on him because wasting court's time. I'll allow you. That's the best. That's the only thing.
Then, my lord, may kindly see the indenture of agreement. Here he says, which is the basis of the case, here he says the first party is the exclusive and absolute owner of the property. My lord, this is the basis on which the check was, I have booked my flats. Here he says that I am the absolute owner of the property. Means the company is not the owner.
But these are all subject matter of trial, my lord. These are all subject matter of trial. Now the question is,
Don't argue arguing against yourself. Subject matter trial, then face it.
No, my lord. What I am saying is, I am raising the question of maintainability, my lord. Maintainability of the complaint. Now, on these two grounds, my lord, the complaint will not be maintainable. And maintainability of the complaint, my lord, I can raise it at any stage, my lord.
My lord, cognizance order of 2015.
There are two more.
I am with him. Today I am with him. I better you get some judgment to save your case.
lordship is now with him. The next
day-
your lordship will be with me.
The day when the person-
Yes. Your lordship can see this document.
I'll adjourn, you file the written note. I'll adjourn.
here-
Come with some judgment. See, he's raising a very technical issue. And even if he is put to trial, he is bound to be acquitted.
Absolutely. Let us
When the
let-
chance of conviction is bleak, my lord,
No more arguing, no conceding. Your lordship is prima facie that the company has not been made a party. Yes, company has not been made a party. But I had showed the notice that the document of indenture, which is the basis of issuing the notice or the basis in which the flats were booked, in that he describes himself to be the owner of the property.
But in the notice, you say in the capacity of director, you have issued the notice. That is
No,
difficult.
you lordship may kindly have a glance to it. Kindly have a glance.
29, come to 29.
Yes, 30, my lord. My lord, may kindly see the entire thing. That in para 30 of the indenture of agreement, it was undertaken by you to complete the flats in all respects. You did not begin construction of such and such.
admittedly, my lord, these are not disputed. These are not disputed.
Indenture is the basis of booking the flats. In the indenture which is there, my lord, that I am the owner of the property has to be tested in court of law. And
For that civil court is there, my lord.
No, that is the basis of which the checks were issued. That is the basis in which the checks were issued. So that has
Para 7 may help you.
that when you aware that when after you paid some amount also issued post-dated check such and such.
It is a fact, it has been issued.
But he doesn't say that on behalf of the company. I'll hear it. Huh? You get some judgment. Today you don't have a case, very difficult case. Very difficult for you. You get cut hold of some judgment if there is a dichotomy on facts also. Whether at this stage.
But I have tried my best to find a judgment against me, but unfortunately.
Let him do that job.
Well, those judgments which my learned senior is relying upon, those judgments were argued by me in Lalit Beriwal case. That was the first judgment of.
That's what he says. You are changing side and taking a different stand.
There the case was different. There the case was different.
Ultimately, my lord, in that case also the company was not made an accused.
Threshold had raised that point after getting the.
I would have straight away allowed his petition. I'm with you only because of the reason that it is 1 decade. He has suffered the.
He has cross-examined me.
Yes, at this stage, the stage is important. Otherwise,
not started.
But the person who has suffered.
I would like to see the evidence also. What the nature of evidence also.
Yes. This document of indenture was brought, confronted.
Have you put that to the?
I have not gone through the.
No, he has not. He has not.
I have not gone through the evidence.
That also I need to see that now.
He has not.
Because see, you have.
Ultimately, my lord, I have suffered.
He allowed the proceeding to go on for a decade.
My lord, I have suffered.
What kind of evidence has come on record? Let us have a glance. In a 482 stage, I shouldn't go into the evidence. But still, in this particular case, I just want to have a glance. That's all.
State the proceeding. Your lordship may kindly call for the soft copy of the evidence.
Yes, soft copy of evidence. Call from the trial court. I'll just have a glance.
Because
what kind of evidence he has led? Let us see. Still, he doesn't have a case. Still, I'm saying he doesn't have it. Very difficult to get out. Yes. Anyway, we'll see.
Today, your lordship may not be with me.
We'll see.
Next day, your lordship may turn with me.
Yes. Next. Yes.
32.
Well, the interim order to continue.
Interim. Yes. Do you have some, my lord?
There are material, my lord. My submission is 304.
Then I'll simply issue notice you.
My lord, they have
And your lordship may call for the cash diary.
They have already entered appearance. May I submit one thing? Your lordship may kindly turn to page 24. The charge sheet file wherein there is not a whisper about the dowry demand. Not a single whisper about
No. If on merit, if you want, that's a different story. You are saying you have settled. It's 304B. Is there?
304, only
Yes.
for that
Then the state has a right to object.
Yes, state has.
And that is
Let
matter.
him file a reply. Let him file a reply.
My lord.
Your Lordship may.
Your lordship
Yes.
kindly call for the case diary also in this matter.
Yes, please call for the case, issue notice, accept notice. And now, shall I?
There is
I'll
my lord.
stay
Yes,
stay the proceeding because
My
they
lord.
have entered into appearance.
My-
Nothing will happen.
My-
Yes.
Stay the proceeding.
My-
Personal appearance or nothing like.
Nothing. You came.
Yes. Appear in.
I need not. Have I called you?
Yes.
I didn't call you.
They have,
Yes.
yes. Obliged.
Yes. 33. 33. None appears for the petitioner in the interest of justice and judge. May for you.
33, your lordships.
Mr. Naik appears for the.
33 is this matter, your lordships.
My lord, 33 is that matter which your lordship fixed at 3 o'clock. If your lordship don't mind, we
Okay.
can take it up now.
Okay.
Yes.
My lord, I am, my lords, an officer of a company called Vesvis, India. Your lordship may not write anything. I'll come there. And the prime accused is the executive director of RSP, Routler Steel Plant. And my lord, 3 and 4, they are agents for various suppliers of refractory bricks to steel plants, but they don't have a mandate from me for RSP. Only to give you lordships a background of this case. Now, we are now concerned with something called a VR3. Your lordship may only note, my lords.
VR3.
VR3 is a voice sample collection which will be in a pen drive. Because whatever is recorded will be in a pen drive. VR3, your lordship may only note. And there is something called a sealing memo, which is the covering page. That's all, minutes. Now, dear lordship, first see page 194. It starts at page 188, and this is the second round before your lordships. Your lordship may see page 188.
Yes.
This is an order passed by the learned trial court.
Yes.
Against my discharge application. That's a little important. And my lords may kindly now turn to page 194, paragraph 12.
194. Okay.
My lords have page 194.
Yes, I have.
Yes. Paragraph 12. The submission of the learned counsel for A2, that is me, that the alleged intercepted calls and voice specimen samples are not legally admissible in the instant case.
You are A1.
I am A2.
A2.
A1, my lord, is the executive
principal
director. Executive. Yeah, grateful. RSP, the executive director of RSP. So what is the submission of the learned counsel for A2, that is me, that the alleged intercepted calls and voice specimen samples are not legally admissible in the instant case, as the same have not been relied upon by the prosecution in the charge sheet. So that is what I say.
Yes.
However, it is seen from the materials on record that VR3 is a micro SD card of Stonatium make, is the exhibit containing audio files. Now kindly see, my lord. And VR2 is the micro SHDC card of 4 GB Kingston make as per CFSL report. The CFSL report has been obtained in respect of the aforesaid voice recording by letter dated 26/12/2017, numbered as CFSL 7/45/4746, which finds mention at serial number 37 of the list of documents submitted along with the charge sheet. So the submission of the learned counsel that voice recordings were not relied upon by the prosecution carries no force. My lord, I challenge.
They were relied upon.
They say, he says so. I say it is not there, he says it's there. Then, my lord, I challenge this order before your lordship's court, my lord. And my lordship may kindly now turn to page 227. Annexure 13.
Yes.
this is an order of 17/11/2022.
Yes.
May I read, my lords, para 2, para 3. The order dated 23/11/21, your lordship saw that order
Yes.
just now, passed by the Learned Special Judge CBI on Bhubaneswar, which is impugned in the present revision application. The revision, thereby the application filed by the petitioner for discharge under 239 was rejected. It is the petitioner's case that he has been entangled in the case without any evidence or material against him. In particular, he has referred to the so-called voice recording sample VR2, which the prosecution claims to contain his voice, which in turn shows that he had conspired with the co-accused in commission of the alleged offences. Mr. So-and-so learned senior counsel has argued at length, referring to the FIR as well as the statement of the witness and the charge sheet. Mr. So-and-so has particularly referred to the report of the CFSL, wherein it is clearly mentioned, your lordship may kindly note this, that VR2 contains no audio file and something has been said regarding VR3, but VR3 itself is not on record. Am I clear, my lord? So that finding that VR3 is on record is now your lordships are saying is not on record.
Not. Yes.
Learned court below has referred to VR3 in the impugned order under para 12 thereof. Your lordship saw para 12 just now. According to Mr. So-and-so, the learned court below could not have referred to a document which does not form a part of the record.
Yes.
Mr. So-and-so learned counsel appearing for my CBI, my learned friend, on the other hand contends, and fairly, my lords, that law permits the prosecution to produce additional documents collected during investigation even after submission of charge sheet. So therefore, we are on the same page that actually there is no VR3, which the learned trial court had recorded while rejecting my discharge application. Mr. Naik has also submitted that CBI has filed a petition on 8/8/2022 before the court below with the prayer to add sample voice collection and sealing memorandum. So kindly note, there are two different things. One is the sample voice collection, that is probably VR3 as we'll further see, and the memorandum, which your lordships will treat it as sealing memorandum dated 14/12/2017 as additional documents to the list attached to the charge sheet. In the body of the petition, it is submitted that the said sample voice collection includes VR3.
Yes.
VR3 means a pen drive.
Yes.
Which is thought to be utilized against the accused. After considering the rival submission, this court finds that VR3 is not on record as yet.
Okay.
An application to include the same is on record pending before the court below. In the fitness of things, the learned court below, kindly note, there are two directions your lordship may kindly underline. In the fitness of things, the learned court below should first dispose of the petition by passing a lawful order. So first he will pass an order whether to admit these documents or not. And I'm grateful. And thereafter should consider the application for discharge. So twofold directions. First you dispose of the
decide, and if it comes on the record, what will be the implication?
Then hear the discharge.
Yes.
Then hear the discharge.
Yes.
In such view of the matter, the impugned order is set aside.
Right.
The matter is remitted to the court below to pass an order on the discharge petition after disposal of the petition. Below to kindly underline after disposal of the petition filed by the CBI.
Yes.
So therefore, my lords, till now we do not see VR3 is not on record as an admitted position, even though the trial court had said.
What happened to the application?
That application was disposed of. I'll come there.
Yes.
Your lordship may now see page 230. Annexure 14.
Yes.
My lords may kindly see paragraph 3. That during investigation of the incident case.
This is the application.
This is the application.
Yes.
No provision under which provision of the CRPC is nothing is stated, but notwithstanding that, kindly see para 3. That during investigation of the incident case, specimen voice samples of the accused persons, including the accused petitioner, have been taken in presence of independent witnesses on 12/1/2017 and 22/12/17, and the same have been forwarded to CFSL Delhi for obtaining expert opinion on the questioned voices of the accused persons. So he's saying that your voice samples have been taken. These are the 2 dates given, and they have been sent to the CFSL. all prior to charge sheet was being filed. The sample voice of the accused petitioner was taken by VR2, was informed to be blank, which your lordship saw, containing the audio and containing no audio file of the CFSL Delhi. Subsequently, another voice sample VR3 of the accused petitioner was taken in the presence of the independent witnesses on 14/12/2017 and forwarded to CFSL Delhi, issued on, based on which opinion has been formed that the report dated 26/12/17 has been submitted, which is listed as document, which is listed as documents, evidence in form charge sheet dated 28/3/2018.
Yeah.
That while filing the charge sheet, so what they say is, this was a part of the charge sheet. While filing the charge sheet in the instant case, the sample voice collection and the sealing memorandum of 14/12/2017, which was drawn in the presence of independent witness during sample voice collections of Sri so-and-so, exhibited as VR3 and forwarded to a CFSL, while covering letter number 6237 dated 18/12/17 copy enclosed, was inadvertently not incorporated in the list of documents.
Yes.
The sample voice collection and sealing memorandum dated so-and-so, by which sample VR3 of so-and-so has been taken before the independent witness and based on which the opinion of CSL on the questioned voice of the accused petitioner has been obtained, by report dated so-and-so, may be taken into record as additional documentary evidence.
Yes.
Now your lordship may see.
Then three documents. One is 14/12/2017
Yes.
is the letter forwarding.
That
And
memorandum.
the sample is
Yes,
VR3.
yes.
Second is CFSL report 26/12/2020.
And the pen drive.
Pen drive.
Pen drive is VR3.
Yeah. Yes.
Would your lordship now see page 71? Page 71. If my lords are kindly pleased to see me.
Charge sheet, huh?
Yes, I'm grateful.
Yes.
It starts at page 43. The list of documents are at page 71.
Yes.
Would your lordships kindly see, my lords, page 73.
Yes.
Serial number 28.
Yes.
The specimen voice recording memos dated 12/1/17 and 22/17. These are the two dates, your lordship saw, my lords.
Yes.
And this is related to VR2, admittedly.
Yes.
And if your lordship sees the next page, my lords, there is nothing about VR3 in this list of documents. That is the first submission to your lordship.
No, that is the reason they moved the application.
What they say is, I'm coming to that. What they say is that this was a part of it, inadvertently not filed. My submission is
not included in the list.
It is not included.
Yes.
Right. Now your lordship may see, my lords. Your lordship may now see what is the impugned order. That is at page 30, annexure 1.
Yes.
This order arises out of two petitions dated 9/8/2022 and 15/1/2024 filed by the learned PP CBI seeking a prayer to add sample voice collection. Your lordship may see Roman 1.
Yes.
Which is VR3. And the sealing memorandum dated 14/12/17 in the charge sheet as relied upon document in the interest of justice. So one is the sealing memorandum and one is the sample voice collection. Am I clear? Let me read further. The learned PP CBI contended that the witnesses who were present at the time of recording of sample V3 of the accused so-and-so are already mentioned as prosecution witness in the charge sheet. The CFSL report dated so-and-so based on the specimen voice sample V3 of Sri Sashikumar Unikrishnan is taken by the IO during investigation on 14/12/17 is already made, relied upon documents in the charge sheet, but you saw it's not there. It is further submitted that during filing of the charge sheet in the case, the sample voice collection and sealing memorandum, which was drawn in the presence of the independent witness, was inadvertently not incorporated in the list of documents in the charge sheet. On the above ground, the learned PP prayed to add what? sample-wise collection and sealing memorandum in the list of documents. On the other hand, the learned counsel for the accused contended that the petition dated 9/8/22 filed by the prosecution seeking to add certain documents, electronic sample concerning the alleged sample-wise collection and sealing memorandum dated so and so after 5 years. He further submitted now at this belated stage the proceeding of the prosecution is seeking to add and charge sheet the above memorandum, which was admittedly in the possession of the prosecution at the time of charge sheet, but the same has not been included in the charge sheet. In such case, wherein, for reasons best known to the prosecution, in such a case wherein the prosecution is seeking to keep record of this document, particularly after 5 years, the defense must be provided with a copy of the right to challenge the same. So what I'm saying is, okay, you want to bring something on record, you have to give it to me. Because it's a part of the police paper now, I'm entitled to have a possession of it.
207.
Learned counsel for the accused further submitted that the application notes inclusion of the purported sample, voice recording and sealing memo dated and so and so.
Ultimately, what does the court say?
No, ultimately, what he says is, if your lordship comes to the last page, he says, it is my case, my lords, that the sample voice collection is not yet a part of the record.
It was not.
Even now it is not. The pen drive has not been given to me till now. So what he says, if your lordship sees, my lords, page 4.
Once it goes to the record,
then it has to come to me.
It has to come to you.
So therefore,
what is wrong in it?
I'm grateful. I am on a very short point. Your lordship said 2 things.
Now it has gone on record. They will have to give you.
They have to give me and then hear my discharge application.
Yes, of course.
That is all I'm asking.
That's the order.
That is all I'm asking.
That's the order. Why are you laboring on that? See, this very specific order for the coordinate bench says that first you decide the application.
Correct.
And now, since some document has come on record, in the as a supplementary charge sheet, whatever you say, it is not even a supplementary charge sheet.
I'm grateful.
So the scenario changes.
Yes.
So you need a fresh hearing. That's all.
I'm very my submission to your lordship is only this. He first said there is a VR3 in the first order. Your lordship said no. Then your lordship said he has filed an application to decide it as per law.
Thereafter you hear the discharge.
So today the court says I have a VR3. He had earlier said also I had a VR3. Give me VR3 and thereafter here. So what he's proceeding to do now, he's saying I want to frame charge now.
Your discharge application is rejected.
He is not rejecting it. Lordship may see this order. Kindly see, my lord, this order. Kindly see page 33, my lords.
33.
Yes.
Yes.
Kindly see, my lords. Later, 24/7/2024. Your lordships have that.
I've seen it.
Accused persons are upset, allowed to be represented.
On the
How can he do this? He has to give me a copy and hear my discharge. Only if he rejects my discharge, he will frame charges.
Yes.
That's all. Because it is our
Yes,
case.
Mr. Naik.
Yes, your lordship. Lordship may give me 5 minutes time.
Yes.
May I proceed?
Yeah.
Your lordships, I was seeing the list of dates. The list of dates doesn't contain 2 dates. The first date is the date of filing of the second discharge application, which is pending before the lower court, because he can only hear it if it is filed. That date is not there in this new petition which has been filed by my senior lordship. And second, your lordship, is that when this order of the High Court was shown to the trial court judge, that discharge application will be decided immediately after the deciding this fresh application filed by us. Those 2 dates are missing, your lordships. First, it had to be demonstrated whether a second application of discharge has been filed by them as per the High Court order or not, and what is the date. And number 2, this High Court order was shown to the trial court judge and he did not pass any order. Number 1. Number 2, your lordships, if your lordships will kindly come to Annexure 13. Annexure 13, your lordships, paragraph 8. In view of the matter, the impugned order is set aside. The matter is remitted to the court below to pass an order on the discharge petition afresh after the disposal of the petition dated 22/8/2022 filed by the CBI.
Yes.
Now, your lordships may kindly straight come to page 165, the CFSL report.
165.
The opinion, which is in page 165, which is filed by the council, which is filed by the petitioner, your lordships.
Yes.
Hence, the voices marked exhibit Q5U, Q8, Q13, Q21, Q22 are the probable voices of the person Sasi Unikrishnan, whose specimen voice is marked exhibit VR3. So this is VR3. The submission that the VR3 is not there. This is VR3 where the voice sample was collected in the presence of independent witnesses. It went to the CFSL and CFSL has given
now don't go into
now your
what
lordship.
he say. See, come to the point.
I want to
Now
your lordship.
VR3, VR2, I am not interested.
Your lordship.
You see, VR3 has taken on record now. You give the copy.
What is the prayer? Your lordship may kindly come to the prayer. Your lordship,
Is it, you tell me one thing. If you form part of the charge sheet, is he not entitled to get it?
Let me argue it. Your lordship may allow me. Your lordship may pass in order, but your lordship may allow me to argue. Your lordship may kindly come to the prayer.
Prayer in the what?
The petitioner has filed a revision application, not 482. Therefore, revision application, what is prayed only can be only granted, your lordships. And the prayer, your lordships, is that the record in the matter pending before the learned be called and examined and order dated 24 July 2024 be set aside. This is the prayer, your lordships. The prayer is not that my discharge application should be heard or why he did not do it, because this is a revision application, not a 482, your lordships, where the scope is limited. Now, your lordships, the only limited question here is that after the submission of the charge sheet, if any material is collected before the filing of the charge sheet, whether that can be allowed by the learned court or not.
It can be allowed. You are rightly allowed.
And your lordships, I have given a judgment to that. It has been allowed.
No, allowed. I am not saying he.
What is the prayer, your lordships?
Prayer is once it is allowed, some document is left out. Now it is included in the charge sheet. Copy of the same has to be given. After he will argue.
Why he is in a hurry, your will give it automatically because this order was passed. Immediately after the order was passed, your lordship.
Thereafter, here is application. That's what he says. What is the big deal about it?
We'll give it, your lordships.
That is the only you supply the copy.
Yes, that will do.
And see, the court has now allowed to bring VR3 or VR2, whatever. Whatever you are bringing on record, he is entitled to that. Under 207. You give it.
Yes, we'll give it.
Thereafter, you hear his application.
But your lordship, the argument is fundamentally wrong because of the fact that there is no discharge application. We'll give it. There is no need to.
Have you filed the discharge application?
He has not given me the copy. No, once he gives.
What he says is, see, don't go into small technicality. What he says is, unless he sees, how will he prepare a discharge application?
If I have not given, your lordship, if I have not given that copy under 207, this petition is not maintainable.
I will record it. How much time will you take to supply the copy? You tell me.
1 week time.
You within 1 week supply and you let him do whatever. He doesn't want to file discharge application. That is his.
Say 1 week to supply, 1 week to file my discharge application.
You why should I say you file or don't file? Let him supply the copy first of all. As simple as that. Once you get the copy, you see it. If so advised, file. If not advised, don't file. It is your prerogative. It is your prerogative after all.
Grateful.
It is your prerogative. See the practical difficulty you just see. Some document has come on record. Unless they see that document, how will they prepare the discharge application?
They should have waited for us to give, na, your lordship.
So therefore, you supply the copy, supply everything.
Because they were in a undue hurry. Before the supply of the copy, they came here.
Anyway, you supply the copy. That's all. Thereafter, they may move.
That is the mandate of 207 CRPC. Anyways, I am duty bound to do it, your lordship.
207, you have to comply.
Yes.
Your lordship may say VR3 has to be given.
VR3 has to be given.
Give it.
VR3 has to be given. Right on.
But your lordship's VR3 is the document. Your lordship, the photocopy we have to give because the original.
I don't know. It is trial court will decide.
Pen drive.
Whatever you are relying upon, the prosecution, everything has to be supplied. As simple as that.
No, because
photocopy, this copy, that copy, I don't know. I am not going to do anything on that. See, you are relying upon something. Let it be whatever. You have to give the copy.
Whatever.
That is mandate of 207.
Yes, your lordships. The document which is being relied upon will be given. Your lordship may not write VR3 or 2.
Your lordship may say, my lords, document.
Because your lordship has not gone through the merits of the case. Your lordship has not perused the charge sheet. Why should your lordship?
I will not get into all this thing. You
yes.
the copy. What?
Yes.
Petitioner is agreed by the order dated. Where is that order? This 20 July.
Page 30.
Order dated.
Annexure 1 minutes, page 30.
Order dated 24/7/2024, whereby the application moved by the prosecution dated 9/8/2022 and 10/5/2024 it has been allowed, and certain documents have been allowed to brought on record.
Actually, there is no 10/5/24. It's a wrong recording by the trial court.
Then which date?
That was the written submission.
Okay. Then there is no two petition, one petition.
One petition.
One petition. Okay. Whereby the petition moved by the prosecution dated 9/8/2022 to bring on record certain documents and materials which was inadvertently left out while filing charge sheet has been allowed.
You also may indicate that which was collected before the filing of the charge sheet.
Has been allowed. The track, I'll reproduce that part.
Yes, yes.
The trial court where is the application? Do you have that application? The application moved by the
30 minutes.
30. You have
The
shown
earlier, the first application.
no. The application dated 9/8/2022. Where is that application?
Page 230 minutes.
230. Yes, you have pointed out that, na? 230. In the application dated 8/230. Yes. In the application moved the prosecution in the application which was allowed by the trial court. Application dated 8/9/2022 moved by the Sub-Inspector of Police CBI Inter India contained which paragraph you have pointed out? Which paragraph? Yes. Paragraph 3, 4.
3, 4 and 5.
3, 4 and 5. 3, 4 and 5. The perusal of the application reveals that exhibit VR3 forwarded to CFSL and the CFSL report obtained has been left out by the inadvertently could not be filed by the prosecution along with the charge sheet. Therefore, the investigating officer sought permission of the trial court to allow to bring on record those documents, namely VR3. What are the documents?
My lordship may see, my lords, page 33.
VR3 33, na?
Page 33, if your lordship sees, my lord. Last but one paragraph, considering the facts and circumstances of the case. Your lordship may record
those documents. The trial court, while dealing with the same application, has inter alia observed as under 33. Last paragraph. It starts from 32 on perusal of the case record. Where is that part you?
On considering the facts and circumstances, just before the order ends.
And on considering facts and circumstances.
Lordship may also reproduce the paragraph before that so that it can be read in toto. On perusal of the case record, it is found that in case of IO submitted the charge sheet from there.
Yes, that
has been recorded.
Both the paragraphs.
Yes.
Both the paragraphs. Mr. Porijar, learned senior counsel appearing for the petitioner, has taken me to the order passed by this court dated 22/7 Kodala.
227.
17/11/2022.
227.
That is at page 227, my lords.
Annexure 13.
Annexure 13.
Annexure 13. Taken me to the order passed by the coordinate bench dated 17/11/2022 in criminal revision petition number 51 of 2022.
Paragraph 7 and 8 are important.
He has emphatically relied upon paragraph 7 and 8 of the said order. The purport of this order is that the trial court is directed to hear the discharge application after hearing the application of the prosecution seeking bringing on record the left out documents in the charge sheet. Since by way of impugn order, the prosecution's application has already been allowed, and prosecution is allowed to bring on record the documents and materials as prayed by them. It is obligatory on the part of the prosecution agency to supply the entire document as per the provisions contained under section 207 CRPC.
No, you lordship indicate that there are left out documents as per this order because
Left out document, obviously.
Yes, yes.
Mr. Naik, learned counsel for the CBI, submits that the documents which has already been, which is now brought on record pursuant to the order, impugn order, shall be supplied to the petitioners within a week.
Will your lordship direct me instead of recording my submission?
Direct.
Please directed that.
Some time may be granted to supply the document. Accordingly, this court direct the investigating agency to supply all the documents which has been brought on record pursuant to the impugn order dated 24/7/2024.
No, that last part has to go, where he says I will frame charge without hearing.
I'll see.
Yes.
Thereafter, in view of the order of the this court dated 2/27, dated 17/11/2022, needless to say that after supply of the documents, the petitioner may choose to move application for discharge. If such application is moved, the same shall be considered. Same shall be considered in accordance with the law. With this observation, the petition.
Grateful.
Yes. You supply the copy, let them take a decision. They may file, they may not file. Yes. Okay. Disclosure.
Yes.
Item 34.
The order may be uploaded, your lordship, sir.
Yes. Yes.
I have filed an I-8, received showing deposit of awarded amount, urgent stage reminder.
Yes. When have you deposited? Learned counsel for the petitioner submits that the petitioner has already deposited the awarded amount.
5th of March.
On 5th of March.
Yes.
On 5th March 2025, and has furnished the proof of the same in view of the proof of the same.
Respondents have already applied.
Disbursement of the awarded amount already deposited shall remain stayed till the next date of hearing. Yes.
Since respondents have already appeared, no notice is required to be sent.
So already entered appearance on behalf of respondent. No notice as such is required. Release the matter for hearing.
LCR, copy of the LCR may be called.
Yes, call for LCR.
From quarter.
Yes.
Obliged.
This is appeal against the RCT.
Appeal, huh?
Yes.
Okay, so entered appearance on behalf of the respondent. Release the matter for hearing. Yes. You file the response if you want, file. Yes.
12th. On 12th.
36. 36. Yes.
Appeal for section 30 of the Employees Compensation Act. Where there is someone has died while running in the railway line. He has
Notice has not gone.
Notice has
Notice. Notice, call for the TRC. Yeah. Call for the TRC.
The execution case has to be stayed. Now the notice has been issued by the executing court for payment of the amount. I have prepared a TDR of the entire amount and offered to the ADM Bolangir to receive the same. He is now directing you prepare the bank draft in the name of the petitioners, though the claimant.
You deposit before this court.
Yes, I have deposit. I have prepared the. I will deposit by tomorrow. Sorry, on Monday.
Subject to what is the amount? Subject to the petitioner depositing the entire award amount.
I have prepared a TDR.
Okay, entire award amount within 2 weeks before this court.
Let's accept this TDR, madam. This is the.
Now it will be invested. Now
It will be invested. It has prepared the TDR. In the name of the ADM Bolangir, because the individual arising out of workman compensation proceeding, the amount has to be deposited with the.
I'll simply say that liberty. I'm granting liberty to give it to the ADM.
ADM, yes.
ADM will invest.
ADM only receive this.
Right. Mr. Saman, learned counsel for the Mr. Saman, learned counsel for the appellant has handed over the TDR drawn in favor of ADM commissioner under Workman Compensation Act at Bolangir.
Bolangir.
At Bolangir. Bolangir. To what is the amount?
amount
to the tune of 8 lakhs,
8,27,652
652 rupees.
52
rupees. He, in view of the photocopy of the same is placed on record, and the original is written to Mr. Samal to deposit before the ADM commissioner under Workman Compensation Act within a period of 2 weeks hence. Disbursement of the amount is stayed till next date of release the matter.
This is already I have annexed as annexer 1 to the IA.
देवाक दरकार नहीं अच्छी तो नहीं जानता नहीं कि दिशा जमा कर दूँ. Yes. Original
The execution
proceeding is state. In view of the aforementioned execution proceeding, particular the agency. Also state. Yes. Part कर लेगी the particular.
I guess.
There already annexer he is filed.
What?
Annexer file procedure. दरकार नहीं दरकार. Execution case at proper the.
One.
Okay. Thank you.